the date of judgment being 21/3/23 and the filing filing date and the appeal was presented on 11/7/23 copy period. Copy period भी नहीं. Copy period नहीं.
Copy period में 3/4/2023 to 22/4/2023.
This court find 2 days भी तो हबो नहीं. Copy period 20 दिन लिखी दी थी और 3 रे apply हला notification 20 अच्छी. All right. This court find from the stamp reporting on the brief on the issue of limitation clearly reported 2 days delay in filing the appeal. Okay, it is in the circumstance this court is inclined to, while ignoring the reporting in the listing, entertain the limitation petition and direct issuing notice in the limitation on the respondent. Requisites as undertaken to be filed by day after tomorrow. You sent the requisites for limitation shall also accompany a copy of the memorandum of appeal. Matter be listed immediately after at least within after the expiry of the date of appearance.
पूरा petition टा दे देबे post रे. So requisites you have to increase that amount.
If possible, both sides xerox कर दियो so that postal expenditure will be less.
Packing भी सुविधा हो. Publish.
Item number 2.
But item number 2, मतलब kind permission मिलट appearing.
What is this additional affidavit?
Well, additional affidavits we have so brought certain documents which were well filed in course of the adjudication of the ID case. That was the additional affidavit. But today, Millard, for lordship's convenience, I am also filing
No,
a compulsion-
undisputedly the documents were already available in the lower court proceeding.
lower court proceeding record. For your
There's
lordship,
no additional document.
no.
Or you
Today,
could have
Millard,
very well filed that. You could have very well filed that along with a memo.
Millard, that.
Not necessary to be. Okay, what is the challenge here?
Millard, the challenge about the award passed by the Millard, the court, ID court, where Millard admittedly the award is Millard may not be enforceable in view of the Millard provisions of the section 238.
No, you challenge the award of the labor court.
Millard, annexure 6.
Just 1 minute. Labor court annexure
6 Millard. As
6 page.
page Millard, the operative person page 159, but starts from Millard,
Okay, this was 33C2 proceeding.
Millard.
You are workman.
No, Millard, I am for the management, Millard.
You are the management.
Millard.
Okay, 33C2, what is the direction ultimately?
Well,
Is
ultimately
in
direction-
entitlement of?
Millard to 50% back wages, that was there. But the background of the case is there, Millard.
It has a foundation of industrial adjudication already.
That is, with due respect, Millard, your
Just-
I don't
just
applaud.
let us
Kindly
take us to the industrial adjudication.
Millard,
Where is the ID?
Millard,
Order.
148. It starts from Millard 148, page 48, page now 148,
140.
48 Millard, annexure 6.
No, that is 33C2 order.
That is 33 steward. After Millard, initial here Millard, the OP number 2 got award in the year 1999, 50% back wages. Thereafter,
It has
the writ petition,
Date award ro?
Our data, my lord,
You are taking help of Ghanshyam Mishra.
Ghanshyam Mishra, and
We are
also,
not support. We have already rendered, this bench has rendered a judgment.
yes, I, but kindly see
So,
my
so
conference.
how can you differ from our judgment?
No, but kindly see my
Our
conference
judgment
note.
ଟା ଦେଖିଛନ୍ତି କି ଆମର lordship ଙ୍କର judgment ଟା ଦେଖିଛନ୍ତି କି?
We have already held pre-adjudication, predetermination will not be affected.
ଆପଣଙ୍କର
And the-
yeah, I think you are appearing this matter for the first time.
And that's why I want to
Just
take my next
mark
week.
the paragraph
Huh.
in the resolution document.
My lord,
Straight away go there. Because that is
Transfer
your
resolution.
my lord.
resolution that
So
straight
next
away
week,
select
next
that
week, Lord
paragraph.
Secretary, today I am appearing, I have not properly.
Get more prepared
Yes,
and go through our judgment.
I'll go through.
We have already decided on this issue.
Maybe I don't know.
My lord.
Little bit doubt.
Yes.
Maybe the same
But
litigant.
my contention before Lordship, Ghanshyam Mishra and the fellow alleged very same particular petitioners, 251 crore, the dues as per SAHOO commission.
ଆପଣ ସେଇଟା ଆପଣ ଗୋଟେ ଅଲଗା ଆଡେ ଚାଲି
ହଁ
ଯାଉଛନ୍ତି
ମୁଁ ସେଇଟା ଯାଉଛି
ଆପଣ ଯାଆନ୍ତୁନି ସିଆଡେ
ଆଜ୍ଞା ଆଜ୍ଞା
confined to the case at hand.
ଆଜ୍ଞା
Lordship has read, we have read that particular paragraph and we interacted with the learned counsel
my lord,
that how you get over that paragraph of your resolution.
I'll get it next week,
You
Lordship.
find that paragraph now so that you will be conscious.
I'll come preparation,
So you have to read the provision in the transfer resolution,
my lord.
then to find out whether such a resolution comes to your rescue in this situation or not.
My lord,
That is what being dealt in the other order. Find
I'll
out
go
that-
through Lordship judge,
Mr. Mishra, if your contention is accepted, as we asked the other counsel,
my lord.
then the Supreme Court judgment,
Yes.
as here it has happened, it has been confirmed by the High Court.
My lord, today I have filed the compulsion.
So can the resolution take away the Supreme Court judgment even?
Yes, that was held in this honorable court also hold. Even the person who has not, my lord, availed.
Person no, court.
Yes,
So after the Supreme Court passes an order, it is not implemented, and the resolution professional enters into the arena. That has been taken care of by the
There also
resolution.
we have taken care
I'll
of
go
that.
Lordship. I will go through Lordship judgment. I will
Hmm.
next week, my lord.
Yes, I'd in fact place the matter on next Tuesday. Okay, the appearance of Sri Lalitendu Mishra by special appearance memo we kept on record. But this appearance memo you have to file every date.
I'll file.
Yes.
But I have filed a compilation for Lordship's conveyance. 5 judgments I have given. My lord is absolute
No,
correct
no,
about
Factually आगा overcome କରନ୍ତୁ
ଆଜ୍ଞା।
ତାପରେ ଆପଣ ତ ସେଟା avoid କରୁଛନ୍ତି
Sir,
ଯାହା
my-
କହିଲେ you are
ନାଇଁ, ନାଇଁ,
avoiding that paragraph.
no, Lordship.
You are avoiding where you have yourself agreed that all such things that will be carried forward. Because then the interpretation becomes a difficult interpretation that no court, no judge, I mean,
Yeah.
judgment will take
This,
given effect to.
then where is this? Where is Saswatacharya?
My lord, he is dengue, found dengue.
Huh?
Dengue, he is the go.
No, he is still continuing or not?
He is there. He is the written
Right.
counsel of the.
Right. No, but we were just thinking if our query has taken him away from the brief.
No.
So, that's right.
I will assist you in
It's a
that.
legal query. Therefore, clients should not find any surprise with the counsels. Okay, all right.
Rather that day would have passed the judgment if you would have been there. Considering his age,
It was adjourned
Lordship
only.
in fact started dictating.
But so far the judgments, my lord, right, you will saying I have go through, but all the judgments which I have filed today in
No,
compilation.
please go through. Please go through.
Straight away କହିବେ
Distinct.
judgment ରେ କହିଲା ଯେ High Court order judgment, Supreme Court judgment ହେଲେ ବି ସେ that will not be decided. And date is very relevant. ଆପଣ ସେ paragraph ଟା ଯୋଉଟା ଏବେ ପଢୁନାହାନ୍ତି, read that paragraph.
I will.
You don't know whether Mr. Acharya has told you. It's very clear in your resolution document.
I will come prepare.
That was read that day.
I will come prepare with Lordship.
Our question fell first
Yes.
was what is transfer resolution?
Transfer.
And he read through that.
As
He
such,
must
like-
have marked that in the brief also. Then he started taking adjournment. Said, I will go through. Because looking to his experience only, we adjourned.
My lord.
Today, you may be surprised to know this. Therefore, please go through our judgment, go through transfer resolution. If it is distinguishable,
I'll-
then place, otherwise simply take away the brief.
I will
Yes.
assist you first.
Item number 3,
Obliged, my lord.
May I please your lordship? My lord, this is a matter under Industrial Dispute Act, my lords.
Tripathi, what is the challenge here?
Yes, my lords. Annexure 1 and Annexure 6, my lords. Annexure 6 is the ex parte award. Annexure 1 is the rejection of my restoration, my lords. But this is a very interesting case, my lords.
No, 1 and 2. What is Annexure 1?
Annexure 1, rejection of my restoration petition, my lords.
Rejection of
My restoration petition.
restoration petition.
Yes, ma'am.
And Annexure 2 is the setting expertise.
Yes, ma'am. That is Annexure 6 is the award, my lords.
Come to Annexure 2.
That is statement of claim, my lords.
Okay, please be on mic. It becomes difficult to hear.
That is statement of claim.
Page
That is, my lord, page 15, my lords.
15.
Yes, my lords.
No, page 15 is statement of claim.
Yes, my lord. That Annexure 2, my lords. And Annexure 6 is the ex parte award, my lords.
Ah, so therefore you challenge Annexure 1 and 6.
1 and 6, my lords.
So what you said 1 and 2.
1 and 6, my lords.
1 and 6.
Yep.
6 is at page. Please give the page number also.
60, my lords. Running page 60.
60.
Yes, ma'am.
There is some problem.
My lord, I am in a different point. Let me.
No, Ruhantu, let us get us. Yes, award is at page 63 rather. That's the notification only. 60 is the notification.
Thereafter, my lords. It's continuous.
63 the award starts.
Yes, my lords.
So this is a proceeding under 2A.
Yes, my lords.
How do you say it is ex parte?
Yes, my lords. I'm coming to this, my lords. My lords, here, what happened when opposite party number 2 was working purely temporary basis.
No, don't come to merit. You say that was ex parte, therefore you have filed an application for restoration.
Yes, my lords.
Okay. First come to satisfy that this Annexure 6 is ex parte order.
Yes, my lords. Your lordship may kindly come to Annexure 7, my lords. That is starts from 73, my lords. Annexure 7, my lords. The
Yes.
entire order sheet, my lords, I have annexed.
Yes, where was you declared?
Yes,
By which order you were declared ex parte?
yes, my lord.
You are management here.
I'm coming to that.
You are management here. Which order?
That is my lord. Relevant page is 79, running page 79, my lord.
Yes. Yes.
The case record is put up today. The 1st March 2022 was for government holiday. Now none appears from either side. No steps taken. PO is on leave, my lords. Then, my lords, 24th April. None appears from either side, my lords. Then, my lords, 8 June. The authorized repent of workman is present. None appears for the management. No steps taken. Then, my lords, relevant 3rd August, my lords. None appear from the side of, but the learned counsel for the second party has sent a petition praying for time on the ground stated therein. In absence of second party, the petition for time preferred by simply kept in record. However, put up the matter on 23rd September.
Document.
No, my lords.
See, 1/11/22.
Yes, my lords. From there, your lordship may kindly come to 23rd September, my lords. Because previous date, inform the management accordingly. That was direction given by the labor court. Thereafter, my lords, your lordship,
Which order you are placing?
that is my lord, page 79, last order. The 3rd August 2022, my
ଏ ମାଇକ୍ରୋଫୋନ ଟା ତଳୁ କେମିତି କରିଦିଅନ୍ତୁ ଆପଣ ଯେତେବେଳେ ପଢିଲା ବେଳକୁ ସେଟା
ତଳକୁ
voice
ପଳଉଛନ୍ତି,
ପଳଉଛି।
ଏପଟେ ହେଇଯାଉଛନ୍ତି, ସେପଟେ ହେଇଯାଉଛନ୍ତି. Set your mic. Yes, so what order you are placing?
That is my
Page
lord,
78.
page 70, that is 3rd August 2022, my lords. The last order, my lord. Inform the management accordingly. Lordship got it?
No. Page 79, sorry. Page 79.
Yes, my lords. The last order, my
Yes,
lords.
3-8, non-appeals for either side.
Yes, my lords.
Hmm.
Both the Learned Council for the second party has sent a petition praying for time.
No, 3-8, no, that's not the order. Non-appeals from either side, but the learned counsel for second party
Second
has
party
sent a
has
petition.
Praying for
Now
time.
praying for time on the
On the
ground
stated
stated in
there, yeah.
absence of second party, the petition for time preferred by this is simply taken on record. Put up on so and so evidence from both sides.
Yes, my lords.
Inform management accordingly.
Accordingly, my lords. Let my lord-
कौन हल्ला से?
Next order. my lords.
Yes.
Non-appeal from either side, the steps taken, notice has been issued to the management by court's memo number so and so,
Right.
SR not back, my lords. This is important. This is, my lord, what happened, my lord? This case is still sub judice, my lords. Because the initially challenged the matter and this matter was stayed by
If
this.
that is your impression, then why have you gone for restoration?
I'm
You
coming.
could have simply challenged the award on that ground. Mr. Tripathi, is it not correct? If that be so, that I have not been served with notice and all these orders are bad.
Yes.
Wrong reporting,
Yes.
you could have simply filed an application for correction of the orders even.
That power they don't have, my lords.
They don't have. Then you could have come to High Court.
Here, my lord, let me clarify.
Who says that power they don't have?
The correction of power.
No, Supreme Court has already held Order 9, Rule 13. Once the High Court said it has no power of 913. Supreme Court said no, it has to follow the civil procedure code. So far as procedures are concerned, Labor Court is to follow the civil procedure code procedures or not.
Yes, my lord.
Then who says it has no power to rectify its own order? And further, Supreme Court judgment.
Yes, my lord.
What is that Chief Minister? Maharashtra? Antule.
Antule.
Here Antule. It is only that court is required to make necessary corrections who has committed such mistake.
Absolutely, right, my lord.
So therefore, what was the necessity? Now you find out what you will be challenged, what you will be challenging. Order 9, Rule 13 justified to be rejected. There is no scope for Order 9, Rule 13.
My lord, my case is completely separate footing altogether.
So you now confine what you will be challenging.
Yes, ma'am. I'm coming to that. Because in 2017, this matter was stayed by this honorable court, my lords. Then when the Supreme Court judgment came, beyond 6 months, the stay will be automatically vacated.
Right.
Thereafter, but the party should be that he should set a date. That is very.
Mr. Tripathi, these authorities,
Yes, my lords.
they post the matter every month or twice in 2 months.
Yes, my lords.
Therefore, it is your responsibility to go there to take the date.
Yes.
You can't put the blame on the court that I was not given notice because High Court had stayed. Therefore, I was under impression unless High Court vacates the stay, I will go to court. I will not go to that court. Where from you got that impression?
Your lordship is absolutely right. But when this order was passed in my favor, that time this decision was not
You
there.
are unable to confine your challenge, Mr. Tripathi.
My challenge is very simple, my lords.
Your challenge now in the given circumstance, you can't challenge Annexure. If you challenge Annexure 1, then we have to dismiss the writ petition.
So, my lord, because this is sub judice, my
Sorry,
lord.
you are unable to pick up. You are unable to pick up. You may have a ground to challenge the award. We
Yes.
don't mind. Hmm? Then take away the. Apply your mind. Understand our implications.
Yes, my lord. I
Next Monday.
oblige, my lord.
Modify your challenge to in the prayer portion.
Because my lord, my petition only rejected only one round. This is a contesting order. When
Mr. Tripathi,
Yes,
there
ma'am.
are so many issues involved here.
yes, my lord.
Even though you say
Yes.
you were not noticed, you did not appear.
Yes, my,
The first question comes to mind, our mind,
yes, my,
is once he has written,
yes,
heard the submissions of the management, unless that attachment goes, the award cannot be touched. So we have given sufficient indication to you.
yes, my.
Find out what way you will be proceeding.
Obliged, my lord. Next point, my lord.
সেটা না হলে এই আওয়ারটাকে চ্যালেঞ্জ করে ফেলবে। It will be simply dismissed. That recording is there, you were hard in your past.
One minute.
আসো next week আসো দেখি।
But the 1/11/22 order is very
Please,
clear.
please apply your mind. We have so many issues already raised.
Yes,
Apply your mind and find out what you will be doing.
obliged, my lord.
For orders item 4. May I lordship. On behalf of Mr. Dimun, I am appearing for the appellant. There is a noting.
Okay, it a necessary correction above. First order करो necessary correction वो 10 lakhs deposit करते हैं 2 lakhs कहीं के लिखा है। Just 1 minute, which order there is type of 14/8/23?
Yes, in paragraph 7, line 9.
14/8/23 typographical error.
2 lakhs.
Order number 17 dated so and so at the beginning line of line number 9.
2 lakhs টা ব্র্যাকেটে ফিগারে 10 lakhs লেখা গেছে।
কোটি সেটা?
Order sheet, paragraph 7,
Alright,
line.
all right. This last but one line, paragraph 7, order number so and so, order number like 17, date 14/8/23. Indication 2 lakhs and corrected as 10 lakhs.
10 corrected as 2.
Yeah, sorry, 2 lakhs.
2 lakhs টা ফিগারে সেটা 10 lakh.
10 lakhs টা word mentioned in bracket in words, 10 word deleted and substituted by word 2. Now come to it. I got you the mistake. But rupees 10 like that. Hence the amount may be corrected regarding correction of typography error. This is stand adjourned to
5/9/2023 को आता है।
5/9. So 5/9 रे ଆସିବ?
Yeah.
That will come on 5/9 as directed earlier.
Obliged. Item
এটাও তো 2 lakhs word রে লিখিল তা ভিতরে কি লিখিছে এটা? ভিতরে কি লিখিল? That also court will see, na? Showing.
for addition item 5.
দেখেই বসাই বাবু। Yes, item 5.
For addition item 5.
This is an appeal pending since 2013. Nobody is showing interest. Dismissed for non-prosecution.
Item 6.
My lord, item 6. My lord, my lord, the matter was last listed on 2nd of August. The matter was last listed on 2nd of August 2023.
Right?
On the said date, my lord has directed for a paper publication.
Yes, substituted service paper publication was directed.
My lord.
You have already
My
got
lord.
the substituted service.
No, my lord. My lord, there were some health issues for the concerned authorized representative of the company.
Pardon?
The
Yeah.
petitioner company is
ଏଇଟା ଦେହ ଖରାପ ସାଙ୍ଗରେ କଣ ଅଛି ପେପର ପବ୍ଲିକେସନ ତ ଏଠୁ ବି କରେଇ ହେଇଥାନ୍ତା। You are unnecessarily lingering. It's a 2014 matter.
my lord,
Your management
my lord.
କାହା ଦେହ ଖରାପ ହେଇଗଲା?
AGM HR ngaro. AGM HR ngaro. Assistant General Manager.
ଆଉ କିଏ ନାହାନ୍ତି ତାଙ୍କ ଅଫିସରେ କରିବା ପାଇଁକା? ତାଙ୍କ ଦେହ ଖରାପ ହେଇଗଲା ତେଣୁ କେସ୍ ଗଡିବ 14 ମସିହା କେସ୍।
My lord.
ୱାର୍କମ୍ୟାନ ଉପରେ ସର୍ଭିସ ହେଇନି କେସ୍ ଟେକେନ୍ ଅଫ୍ ହେଇପାରୁନି।
My lord. ହେଇପାରୁନି। My lord, for that ମୁଁ
ରିପିଟ୍ କରିବାର ଅଛି। Again repeat କର। Unnecessary. As if there is no other officer available there. It's an office, it's not an individual.
my lord.
ଏଟାକୁ repeat ଲେଖା unfortunate. It is unfortunate to note that the order dated 28/23 could not be worked out for illness of one of the officer of the management involved therein. This court, while deprecating such attitude, however, considering oral request, extend the. You have already submitted the draft application.
My
or
lord,
not?
my lord.
Considering draft publication is already submitted to the Register Judicial. Register Judicial is directed to approve the draft paper publication within a period of 3 working days.
My lord,
Let there be paper publication of the news item published in the locality of the opposite party number 2 by 3 days by 29th August. 3 sets, let there be also filing of 3 sets of paper publication within 3 working days of the publication. Bring the matter on board on 4th of September
my lord,
with a reporting of the registry on the appearance position.
my lord, this registry already approved the course search. Registry already
ହେଲା sir ଯଦି ହେଇଛି ସେଟା ତ କିଛି ଅସୁବିଧା ନାହିଁ
My
ନା।
lord,
ତାଙ୍କୁ 3 ଦିନ ଟାଇମ ଦିଆହେଲା କାରଣ the order has to be repeated.
my
You
lord,
could not catch that word.
my lord, my lord, my lord.
Order has to be repeated again. तार पुनी सेही process चालिବ correction हबो correction ହେଇକିରି ଆପଣଙ୍କୁ ଦିଆ ହବ approval date
ସେଇଟା ଆପଣଙ୍କର ଗୋଟେ approve କରିଛନ୍ତି expedite ହେଇଗଲା ଆଉ।
My lord, my lord,
Further time has to be granted because the process has to be redone.
my lord.
ମୋ ନାଁ ହଉଛି ଆକାଶ ଆଚାର୍ଯ୍ୟ। ଆକାଶ ଆଚାର୍ଯ୍ୟ।
Obliged lordship.
Yes, next.
Item 7,
May I please, my lords? My lords, I have filed interim application
Just 1 minute. This order disposes IA 12704 of 23. এটা recall extension পর্যন্ত। oral submission considering the submission. ହେଲା?
Flag B ରେ ଅଛି।
ଠିକ
Record ରେ ଅଛି।
ଦେଖେଇବ draft କରିକି। Next, yes. Yes, Mr. Das.
May I please, my lords? My lords, in this
Modification to what extent?
modification, only, my lord, in the order dated 31/7/2023, the last line is parties are not showing interest for hearing, deletes the matter. Actually, as a matter of fact, on 31st, I couldn't be before your lordship.
That
by-
was a veiled threat to you that you comply 17B or you
Yes,
face the
yes, yes.
consequence.
I was about to say
So
that.
the lordship is a master of this kind of litigation.
I know it.
So you must understand that.
Yes, ma'am.
So ସେଟା ଆପଣ ଏଠି ପଚାରିବେ ଯେ କଣ କାହିଁକି ଲେଖା ହେଲା modification
Then
ହବ।
we can only learn till
From a
yes,
youngster like Mr. Acharya, it is expected.
my learned senior said what I wanted to say. Daily we are learning. I have filed this interim application with a prayer only that matter may be taken up any day suitable to your lordship. Even next week also can be taken up. Only same, besides other things, the question of law involved is whether collection of revenue is a sovereign function of the government or not.
17B comply kale ki?
17B ର ଯେତିକି comply ହେଇଥିଲା affidavit I filed. I was telling my lunch senior, this morning only I received telephone instruction that it has already been approved. By tomorrow or day after, rest of the amount they will be paying.
Okay, then it has
Your
come
lordship
for
can quote me
hearing.
also.
It has come for hearing.
Sorry, ma'am.
Now the proceeding is for hearing.
Yes, my lord.
So argue.
If your lordship, today I that judgment bunch, bulky bunch, only I have given to my lunch senior, but to your lordship, the other day your lordship said.
The matter is already delisted. Why it has come again? No, for your miscase only.
Oh, yes, my lord. There my prayer is your lordship may list it. That portion may be modified. Delist the matter, that portion may be modified. I may be allowed that the matter may be heard any day.
Delisted hele to habo hearing habo mo pare hearing habo kon ଅଛି जो bench ଆସିବ ସେଠି ହବ.
Delist ଟା କାଟିଦେଲେ ଟିକେ ଆପଣ ଶୁଣିଲେ ବି next week ରେ ମୁଁ
ନାଇଁ
I am
next
prepared.
ମୁଁ ତ ଶୁଣିବା ଆଉ ସମ୍ଭବ ନୁହଁ ତେଣୁ
delist ଟା ଖାଲି delist portion ଟା କାଟିଦେଲେ
ଆରେ ମୁଁ ଯୋଉଟାକ ଶୁଣି ଆଉ ପାରୁନି ଆମ ବେଞ୍ଚ ରେ ଆମେ
I understand, my lord,
କରିପାରୁନୁ
I
ସେଟା
understand.
ଡିଲିଷ୍ଟ କରୁଛୁ that's a language used. So କଣ ସେଥିରେ disturb ହବାର କଣ ଅଛି?
ଲିବର୍ଟିଟା ନଉନାହାନ୍ତି
that
କରିପାରିବେ ଲିବର୍ଟିଟା ଯଦି ନେବେ even though it is delisted
ଆଉ ତାହେଲେ
immediately
ଠିକ
ସେ
ଅଛି।
move କରିପାରିବେ
ତ liberty ଦେଇ ଦଉଛି
yes,
और କରୁନାହାନ୍ତି ବୋଲି ସେତେବେଳେ ଲେଖା ହେଇଛି
that will do, my
okay
lord.
now that all right IRA ସେ order କରିଦବା so we record your
Submission that-
undertaking the 17B exercise
Yes, my lord. Yes, my lord.
and you are going to release the complete amount by day after tomorrow
Day after or 2 days, within 2.
by end of this week.
Yes, man. Yes, man.
All right. Okay, IA is 12594 of 23. And this is an application for modified the submission of Sri Das and Sri Rautre Senior Counsel for the other side. As well as state भी अछंती कि त्रिपाठी
State nine. State nine.
सेंट्रल गवर्नमेंट तो कहीं ना सरकार सरकार पैसा रही this is an application for modification of order dated 31/7/23. This court clarifies only on the ground of non-compliance of 17B, the court was constrained to pass the order dated 31/7/23 while also delisting the matter. In the course of submission, this court records the submission of Sri Bimbisara Das, a DSS court, Das advocate, Senior Panel Counsel, Government of India, on instruction submits.
This morning I received
There
instruction.
is on instruction received today itself. The instruction on the basis of instruction received today morning brings to the notice of the court that part of the 17B amount is already released
Madam.
and the balance part payment is under calculation and the petitioner herein undertakes to release the balance part by end of this week.
Madam.
It is for the undertaking recorded herein above. This court disposing the IA, providing opportunity till end of this week, also grant liberty to the counsel for the petitioner to request in the next listing, in the next board for expediting the hearing of the matter. This disposes the IA. See, there are decisions, Mr. Das, you will find, Mr. Rautra, of course, is master in education and civil. I decide there is decision, unless you pay the 17B, you are not making the workman able to contest the matter.
Yes, I understand that. I have seen that judgment.
Sustenance is in stake.
I have seen that judgment.
So therefore, one is bound to.
Another point I'll like to advance, Your Lordship, that delay is not only from our side because non-employment certificate they are required to give. For 5 months, 6 months, they are not giving. That is a problem.
Filed affidavit every.
No, in that event, what is your information that he is receiving some money?
No, that
So,
information is
why
not,
should you sit silent?
that information is not there.
Oh, see, you are burdening the workman. Where from he will
That
get
I
such
understand, ma'am.
affidavit? He is to come to a lawyer like Mr. Rautra, then get a preparation. So you have to consider all these things. You have your office staffs. You can send a person to find out. That cannot
No,
be
that
impeded.
cannot be. That cannot be.
He is in fact in employment or not.
Yes, that is
So
true.
therefore, not that every month he will come and give a affidavit for release.
No, that was never.
Like bank is insisting as a life certificate.
Every month, life.
Sorry. They can very well send a person to the person of the beneficiary house, find out whether he is live or not. And he is asking a 85 years old man to bring a life certificate. Unfortunate to see these situations.
That law
If you go to
requires it.
State Bank now,
Yes, yes, I know that.
just tomorrow, some of you come through the State Bank at 10 o'clock
My lord.
or 9:50. You will find number of old people are sitting on the staircase of the State Bank.
I have seen my own uncle. Till date, he is going.
And the reason of waiting is there to provide the death certificate, the life certificate,
Yes, my lord.
in order to draw their pension.
Yes.
They don't have arrangement of seating of the senior
It is
citizens.
nothing,
even.
nothing.
And you want workmen will give certificate every month in your office.
State Bank has monopolized pension processing.
Bank veranda.
আজকাল
Your
অপরাধ-
officer can very well visit these pensionaries. They have their account in your bank. You are running your business on their account.
ଏବେ ହେଲାଣି ଏବେ
ନାଇଁ ମ ହେଲାଣି କୋଉଠି ସବୁ ବ୍ୟାଙ୍କରେ ତ
learned senior will better say in education appeals which we file before the director of higher education or secondary education, not as tool even, bench even, chairs even, advocate stand and case will be taken up to 3 p.m. 10টা 3টা সেটি ঠিক আইতে বলতো
Unfortunate.
কিছু চেয়ারটা না
humanism must prevail.
my lord.
Yes, next.
Sorry.
Item 8.
May I present?
Just 1 minute, Mr. Rautra. Mr. Rautra, why are you prosecuting with these content matters?
You are not press your.
Close kar do.
Close kar.
Data ka content matter item
Because of
7.
the today's statement, you are.
Not pressed. For the statement recorded, for the statement of Sri Das recorded in the disposal of IA number 12594 of 23, there is no further cause of action surviving in the contempt application so and so and so and so. Dita kare vote order kar do, which are dropped for the timing. Yes, item 8.
May.
Hmm.
Petitioner is the my lord, appellant my lord husband.
Okay, mic to set for on the
Madam.
first.
Petitioner is the husband,
Petitioner is the husband.
my lord. He has filed a application on section 13(1) on the ground of adultery, my lord.
Hmm.
And
On the ground of adultery.
my lord, the
So
opposite,
ଆପଣ ସ୍ତ୍ରୀଟାକୁ ବର୍ବାଦ କରିଦେଇ ରଖିଲେଣି.
the opposite party, my lord, though
ପୁଅଟାକୁ ବି ଆପଣ ବୋଧେ କହୁଛନ୍ତି illegitimate.
person may remand the matter. So,
Is it expertise?
yes, ma'am.
Come to the judgment.
Page 7, my lord, yes,
Should it
internal page
text
2, my
party?
lord. First para.
You did not appear.
On the other hand,
You did not appear.
no, opposite party has not appeared. Respondent not appeared.
My lord's query. How you are agreed because you have been heard. It's not that you are experting.
Your
No,
case is
I am
not
not.
believed.
So then.
Your case is not
You
believed.
see, your case is not believed without a WS and
So
appearance
you
and
want
evidence.
to now consolidate your case by remand. The other side has not come. Other side cannot come. She is in benefit because the matter has been. She has come because of notice,
My lord.
but she has no grievance here. She is happy with the dismissal order.
Yes.
So we don't find any ground we dismiss because you have taken out the character of the
My lord,
wife and child.
though she has the law and court below has admitted, my lord. That
Who has admitted?
law and court below, my lord.
Huh?
Lordship,
Who has admitted?
My lord, court below, my lord, upon my evidence.
But how court?
My lord, I
court
have-
below can admit.
He has elope with his with
They have
her,
not proved the.
elope
other-
with her, my lord.
Mr. Tripathi, how a court is a party and can.
No, court, my lord, I have laws and affair, my
Not
lord.
to say, sir.
I have
court-
laws and
court has
affair.
given a finding.
I have,
Court has
yes,
given a
yes,
finding
that
that she has
is, that is.
Court admit kala
Where,
will.
where the court's finding?
My lord, I have, your lordship, page 3, my lord. Page 8, running page 8, my lord.
Second line.
Yes, page 22. Running page 3.
My lord, your lordship, second line, however, lordship got it.
Yes, however,
However, the petitioner has not produced any documentary evidence to show that in actual he has reported in writing to the police regarding the extramarital
no, that's a
relationship.
finding of fact.
No, next,
Yes,
my lord,
you
no doubt,
failed in producing.
no doubt a single act of adultery cannot
that's an
amount to live
observation.
in adultery.
That's an observation.
Yes, my lord.
There, you may
Then
succeed.
next,
You
my
could
lord,
say- You could
next-
have succeeded even if you have produced such document. That's an observation only. I had had the submission of Tripathi Learned Counsel for the petitioner and Sri Bose,
No, lordship.
Dwivedi.
Lordship.
Dwivedi,
Sitakant
learned counsel
hota.
for the wife appearing here.
ଆପଣଙ୍କ ନାଁଟା
Sitakant hota.
ପାୱାର ଅଛି ନା ଆପଣ ସେଟା ନିଜେ ଦିବେଦି ମିଷ୍ଟର
No, no. Sitakant
ଆପଣଙ୍କ ନାଁଟା
hota.
କଣ?
Sitakant hota.
ଏ ନୋଟା ହେଇଯାଇଛି
ହଁ,
ଶେଷଟା
ସୀତାକାନ୍ତ ହୋତା. All right. Right. ଏଠି ଲେଖା ହେଇଥିବ ଯେ ସୀତାକାନ୍ତ ହୋତା ବୋଲି.
No, lordship. Seta en hota. I am appearing on behalf of Divedi.
Though wrongly noted in the list as N hota. Repeats the matrimonial appeal. Both sides take your seat. Involves a challenge to the judgment passed by the family court, Judge Family Court Noida, involving an application under section 13(1) of Hindu Marriage Act at the instance of the husband, registered as CP 32 of 16, and in the dismissal of such proceeding. Taking this court to the grounds taken in the memorandum of appeal, reading together with the observation of the Judge Family Court. In the 5th line, internal page 3 of the judgment, impugned judgment. Counsel, Sri Tripathi counsel appearing for the husband claims for there is already admission by the Judge Family Court Noida. The proceeding should have been allowed. Sri Tripathi also, as a second ground, challenges the impugned order for its being in expert, for its being expert in nature. Sri Hota, learned counsel appearing for the wife herein, the wife respondent herein, while admitting that the wife in the proceeding remained expert, however, taking to the observations and the finding of the Judge Family Court Noida, claims the impugned judgment is justified, requiring no interference in the same, and thus request for dismissal of the matrimonial appeal. Considering the rival contentions of the parties, coming to the second round of challenge, this court find undisputedly the wife respondent therein also a respondent herein was ex parte. For there is dismissal of the 13(1) proceeding of the HM Act proceeding. Ex parte dismissal of the suit cannot create a ground in favor of the appellant herein, the petitioner in the original proceeding, for revival of the proceeding. If he is to succeed, he is to succeed on the merit aspect only. Coming to consider the ground of challenge on merit involving the impugned judgment hearing, this court find the Judge Family Court taking into the totality of the pleading, evidence, and the submissions made therein has come to observe as follows. Para 4 ta quote kariba na. Next, reading the observation and the findings of the Judge Family Court, this court find there has been consideration of the pleadings, evidence, threadbare consideration of the pleadings, evidence, and the submission, and finally finding no support to the case of the petitioner, the appellant herein was pleased to dismiss the proceeding. On the claim of the appellant, on admission of the Judge Family Court, this court observes there is no question of a court admitting to some contentions of the parties, any contention of the parties, except observation made therein to such effect has to be taken as an observation of the court. Counsel for the appellant leading his case on the recording of the Judge Family Court to the effect, no doubt, a single act of adultery cannot amount to live in adultery, appears to be a proposition dependent on the pronouncement of judgments, not an opinion involving the case. Also, and maybe at best constitute to be an opinion of the court. Okay, as a whole, this court find there is no merit in the matrimonial appeal requiring interference in the impugned judgment. The appeal stand dismissed. However, there is no order as to cost. Same set of repetitive.
Puri, you were appearing in that matter.
No.
Same name, similar name and Puri. So I thought that matter. Okay.
Puri.
But here it is a minor girl.
Yes.
ଆପଣଙ୍କ ନାଁଟା କହିଦିଅନ୍ତୁ ଆପଣ ସେମିତି don't because
ସେ-
because there is a wrong
ଭୋକାଲାତରେ ତ-
recording
ଭୋକାଲାତରେ ଏନ୍ ହୋତା ଅଛି।
ଆପଣ ଏନ୍ ହୋତା ତ
ନିରଞ୍ଜନ ହୋତା
ଆପଣ ନିରଞ୍ଜନ
ନା ନା ସୀତାକାନ୍ତ ହୋତା ଲର୍ଡସିପ
ସୀତାକାନ୍ତ କହିବେ ନା that then becomes a wrong recording by the
On behalf
court.
No,
of
I am
Sitakant.
Sitakant होता on behalf of the
एस द्विवेदी
କରିଦିଅ on behalf of ଦ୍ୱିବେଦୀ କରିଦବ
लर्डशिप
ଗୋଟେ appearance memo ଦେଇ ଦିଅନ୍ତୁ।
लर्डशिप
Yes. ସେ ଯୋଉଟା ତାହେଲେ ଲେଖା ହେଇଗଲା ଯେ though wrongly recorded ଠିକ ଅଛି।
One small
Item
paragraph,
9,
item 9, my name may be deleted.
Yes, 9,
My name may be deleted. My name may be deleted. I have already.
ହଁ ବୁଝିଲି ଛାଡ଼ନ୍ତୁ ଆପଣ ପଳାନ୍ତୁ ଆପଣ କାହିଁ ରହୁଛନ୍ତି। Yes, who is for appellant? You are there, madam?
I am for the appellant, my lord.
You are for the appellant?
Appellant, wife.
All right, are you ready to argue?
Yes, my lord. Yes, my lord.
Yes. କାହିଁ ଆପଣ written note of submission କାହିଁ? ଆଜ୍ଞା ସୁପ୍ରିମ କୋର୍ଟର ଗାଇଡଲାଇନ ଦେଖିଲେଣି? On written note of submission
So I am not reading.
କିଛି ତ ଦେଖିବେନି ଆଉ ସବୁ ଖାଲି ହାଇକୋର୍ଟରେ ବଡ ଓକିଲ ହେଇଗଲେ ହବ କେମିତି? Supreme Court has recently a guideline, kind of sometime lawyers go and file SLP saying, I have taken these grounds, but the court has not considered. So now court is binding the lawyers to avoid such allegations in higher forums. Even review applications in Supreme Court also comes on that premises. So better ଆଣନ୍ତୁ written note of submission ଆଣନ୍ତୁ ଦେଖିବା ହେଲା ଏଇଟା wife ର କଣ ହେଇଛି wife ଆସିଛନ୍ତି husband ଙ୍କର divorce allow ହେଇଯାଇଛି
Yes, my lord. Previous date the personal
a
appearance
judgment
ହେଇଥିଲା.
will be necessary. 2000 ଟଙ୍କା ଜମା permanent alimony
No, no, 2 lakh ଟଙ୍କା. He is
2
earning.
ଲକ୍ଷ ଟଙ୍କା
Again, she is earning. She is getting 1
He is
lakh.
earning.
Flag B ରେ ଦେଇଛି ଆଜ୍ଞା ମୁଁ।
Mind dear problem.
କଣ ଷ୍ଟେ ହେଇକି ଅଛି ନା କଣ ଇଣ୍ଟରିମ୍ ଅର୍ଡର ନାହିଁ?
ନାଇଁ
ସେ ଯୋଉ ଆସିକି ଏଠି କହିଲେ ତ ତାଙ୍କୁ
my lord.
My lord.
As an-
କ୍ୟାଫେଟେରିଆରେ ବାଡେଇଲେ ବୋଲି କହିକି ଯୋଉ ସେଇ ଲୋକ ତ ଇଏ
Yes, your lordship.
As an interim, there shall be stay of operation of the judgment. Pura judgment stay, right? Wife since challenging the divorce grant, it is bound to be stayed. देखिए release कर दो next bench रे क्या आसिबे कर.
ଆଜ୍ଞା।
There is no time for final hearing of such matters. Matter released to be listed in the next bench. Next assignment कर दे. innovative application. Law ନିଜେ clean କରୁଛି ଯେମିତି ଥାନାରେ ବସିକିରି yes.
item 10,
Item 10 ଏଥିରେ କଣ review petition ବି ଅଛି?
My lord, there was an order passed by your lordships against the management upholding the award, which the management filed a review and your lordships accepted the review and the writ petition was to be heard. And this is coming up after that order of your lordships 13/4/2023, by which the review was
What was the order sought to be reviewed?
the main order, which was passed in the writ petition.
Let us come to the review application.
Can I just tell your lordships before that?
Flag X.
Before that, if your lordship will look at your lordship's order 19/1/2023, your lordships had directed me to deposit the amount which was awarded by the Labour Court. Pursuant to your lordship's order 19/1/2023, we deposited 20 lakhs odd rupees.
Okay.
And your lordships also directed to file the calculation sheet. Now, I have been told by
What is the order you are referring? Order date?
19/1/2023.
13/1.
19/1/2023.
Nineteen one 23. There is some order.
That's the order in the review petition.
That's the order in review.
Yes, my lord.
Then review
May I
order
just-
sheet, where is the review order sheet?
Yes, my lord. It's a small paragraph. Can I read it?
Provided we get that order sheet. Review file achi ki? There must be a order sheet in the review file.
Yes, my lord. I have copies.
Here the review is marked as flag X. Because in the main order sheet, we
My
don't
lord,
find.
I have the copy.
Retrace. Rough. Okay, that is further order to keep it in fixed deposit also.
No, my lord. I'll just tell your lordship. Your lordship will look at paragraph 4. The back wages were to be deposited, and also a calculation sheet has to be filed before your lordship.
That order we are not getting.
My lord, I have just handed over.
Now that you are extending, where is our file? Where is our file? That is by some other bench.
Already been disposed of.
The review petition-
My lord, I had a
review
different.
file achi.
Lord, I had a different.
Same thing hala tale order. Because this is order number 2 again. So there is some review order sheet also.
Yeah.
There must be review order sheet. Review is an independent application.
That may be called for.
Flag X, we may be flag X here.
The lordship may call for the records of the review petition.
No, flag X is that order only. So review is disposed.
Yes, my lord. I just want.
Okay,
My
okay.
lord, I have a different point to place before your
Pursuant
lordship.
to an interlocutory order passed by this court on 19 May, so and so, the review petition, the management has, okay, in the opposite region, the court reviews and recalls the order dated 20th. That is, Madam Ponda order has been
Yes,
recalled.
my lord.
Now the read petition is restored.
Restored.
And the further development, you have deposited 20 lakhs odd, that has been kept in
My
fixed
lord, that's
deposit.
exactly what, there's a point here, there's a catch here. That I have been informed that the calculation has been erroneously done, and an additional amount of about 3,70,000 has been deposited. So I just wanted, if your lordship can permit me, I'll file an affidavit with the calculation sheet. Let 20 lakhs be deposited. We do not want that
That
money.
may you bring onwards, there is no issue. There is no issue, you may put up appropriate application for consideration of the court, not on oral submissions. Now come to the writ is revived, so writ is ready for hearing.
Yes, my lord.
So what is the writ involved?
My lord, the main issue involved, which the Honorable High Court in the earlier round of litigation had not considered, is whether the respondent is a workman within the definition of Section 2S of the Industrial Disputes Act. That's the main issue.
Come to your prayer.
Yes, my lord. Lord, the prayer is at page
You challenge an award
27.
here.
27.
You challenge an award here.
Yes, my lord. Yes.
But you are now submitting that some order, there is some wrong order of the High Court.
No, my lord, the High Court, which is order under review, the order under review was the order which was erroneously passed because the High Court did not consider as to whether he was a workman under the provisions
So
of
you
the.
challenge the review order.
Sorry, my lord.
You challenge the review order.
No, my lord. I'm not challenging. My review order is in my favor.
Your favor, now you
Now
challenge
the
the
writ
ID award.
Now the writ petition has been restored
Restored,
We have
involving and a challenge to the ID award.
to the award.
So award under what ground you are challenging?
Award because the labor court frames the question as to whether he's a workman within the definition of 2S, but doesn't answer that.
Come to that.
Your lordship will look at the award.
That's the only ground of challenge.
That is the main ground.
You
And
have seriously contested the matter on the footing that the workman is not workman in terms of the ID Act.
ID Act 2S.
Okay. And having a issue having been framed has not been answered.
Has not been answered in the sense that he was admittedly getting a salary of more than 19,000 rupees. If your lordship will look at page 29.
You are shifting your argument, Mr. Misra.
Sorry, my lord.
Your first submission was, even though an issue was framed, but it has not been answered.
Yes.
Now you are saying,
Yes, my lord.
even though it has been answered.
No, my
but
lord, it has not
wrongly
been answered. That issue has not been answered. That particular portion.
So confined to that.
Yes, my lord. Page
You are
32.
deviating sometime, I find.
Page 32.
So come to the framing of, first come to the written statement stand.
Yes, my lord.
You have filed the written statement. Where is your question?
Yes, my lord.
Page
Written statement is at page 48.
Yes, 48. Come to that part.
Yes, my lord. Page 51.
Just 1 minute.
Para 2 you should actually maybe start with para 2 because earlier you are saying that he was a field engineer in L&T.
Yes, my lord.
From there he got he got engaged in Navabharat.
Yes, my lord.
Now, yes, para.
If your lordship will come to page 51, he was an engineer and previously working with L&T from 2009 to 2010. Now, if your lordship will go to para 51, on completion of the traineeship period, the disputant by the office order dated 6/2/2013 was placed in
Just
the
where are you reading?
page 50,
Page 51?
paragraph 2, small Roman 6.
Yes. On completion of?
On completion of the traineeship period, the disputant by the office order dated 6/2/2013 was placed in the post of supervisor operation in PSS 1 supervisory cadre with effect from 14/12/2012 on probation basis with a salary of rupees 1,85,112 per annum. And his total salary per month was fixed at rupees 15,426. It is pertinent to mention here that by clause 5 of the said order, the appointment, there was a stipulation that during a period of probation, either party can terminate the services of giving other party once notice. Now, if your lordship will come to paragraph 2, small Roman 7.
Roman re kon capital achi?
Yes, my lord. There's capital as well as small.
Acha. Small Roman and capital. जोटा भी आई बड़ा अक्षर in the
That's how we were taught in maths during our school days.
Yes, read.
It is worthwhile to mention here that subsequently by letter dated 29/5/2014, the disputant was confirmed with effect from 14/12/2000 in the position of supervisory, and his CTC was increased by another rupees 30,324. And the revised CTC.
That's right. Why are you not coming straight away? Why have you said that he's not a workman in this circumstance? You are reading so many things, but nowhere you said he's not a workman.
Page 55.
Is?
Page 50. Page 55.
55?
Yes, ma'am.
Yes.
If your lordship will look at the first paragraph with which is written in bold, such contract being terminated under stipulation in that we have contained therein, and the said alleged.
13
Page 55.
Page 54.
Page 54, 2 Roman 13.
Yes, ma'am. Yes, ma'am.
Disputant
obliged.
being a
Yes, ma'am.
supervisor officer
Yes,
is
ma'am.
excluded from purview of definition of workman.
Yes, ma'am.
So
And
come
if your
to
lordship
that
will just
straight away.
and if your lordship will just turn over to page 55 also. It says that the present disputant under section 2S4 of the ID Act 19 to approach this learned court, he being excluded from the definition of work.
Right, 55 first para.
Yes, my lord.
Right. That is continuation of
2S4.
Roman 14.
And now if your lordship, if I may take your lordship's
So you have taken a clear stand.
2S.
Now come to the issue.
Yes, my lord.
Award is annexure
Annexure 1.
1.
Yes, my
Yes.
lord. And the issue is that issues framed is at page 32.
Yes.
Whether the second party
First issue.
First issue.
Right.
If your lordship will come to page 33.
Just 1 minute. Before that, he has recorded the case of the parties.
Yes, my lord.
Has he taken note of that?
No, my lord. That particular section 2S4 has not been taken into account. There's only a mention. There is only a If your lordship will come to page 33, he mentions that he gets salary more than rupees 10,000.
Say, he has not taken properly note of your case even. Para 3 re.
Lordship is referring just above para 3.
Yes.
Actually, he has referred it to the contrary. In his claim petition, the second party, the workman. Second party is the workman here.
Yes, ma'am.
So then he has noted his contention, but I have not noted.
Your contention has not been properly quoted even.
Now, 5 engineers were terminated at the same time.
Go step by step.
Yes,
go
but
step by step.
Because this is very important. It has some relevance here. That's why I'm saying 5 engineers services were dispensed with at the same time. Only 2 of them, one went to the industrial
We'll
tribunal.
go to merit subsequently. First, let us see how he has dealt with this issue.
Yes.
How the learned court, where he has dealt with or not at all dealt?
Not at all dealt with, because if your lordship will look at page 33, the labor code deals with that rupees 10, more than 10,000 as salary. But if your lordship will read that issue number 1, that has not been dealt thereafter. At page 33 per contra, it is argued on behalf of the management.
It is.
Right. It is settled principle of law ko sidha jump kariya.
That since the second party was a supervisor and was drawing more than rupees 10,000 per month, and so also the powers vested on him were mainly of supervisory and manager, he's not coming under the definition of workman.
Yes, who appears for the workman?
Lord, I
Yes,
just have one more thing to say. 2 of them went, one before the labor court, which is we are presently before you, before your lordship, and the other one went before the industrial tribunal. The industrial tribunal, relying upon section 2S, has rejected the
Is that binding on us?
and they came up.
Is that binding on us?
No, my lord, I'll just
Therefore, we are taking a
No,
view.
my lord,
Why are you on that?
my lord, I'll just tell. They
Why are you
came
on
before
that?
your lordships. The work.
I know this branch of law.
They were.
Don't worry.
No, my lord, I'll just, if your
Don't
lordship.
worry.
The workman came before your lordship.
Therefore, High Court order may be helping you.
The
High Court order
Yes,
may be
my lord.
helping you.
And
Where is that judgment?
my lord, that was filed in the review. I could not file it. It is not
Oh,
there. It's not
right.
uploaded. But the writ petition was dismissed as withdrawn.
What is the writ petition number? Workman must be knowing.
That copy is also. That is a new plea taken at the
Tribunal को से negative करते. However, payment always involved. It is nature of what somebody is doing. Therefore, let it go back. Let him decide on issue number 1.
They had already issued there.
Mic rekondu, mic.
My lord, that is WPC number 1964 of 2019. 6/4
of
2019,
decided date is there.
22/9/2022.
Yes, sir. Give a copy of this order. Your computer people.
This writ petition was dismissed as withdrawn.
Or dismissed as withdrawn, then that is not a
1964.
dismissed as withdrawn.
Because
then there is no finding.
I was appearing in this matter, but since I won't be
No,
able
no,
to-
sir. Dismissed as withdrawn cannot be a judgment.
I
to be
won't be
followed.
able to tell that the court was not inclined and
Forget
therefore it
that,
was
forget that. We can take a view independently.
very well.
We can take a view independently. That cannot have a
but can I
persuasive
just-
value even.
Can your lordship just have a look at 2S instead of remanding the matter at this stage?
So let Mr. Ratha answer. Actually, I think you.
Yes, Mr. Ratha,
Need some time.
please be on mic and argue.
My lord, I need some time to brought this on this
You
one
need
because this
time.
will be a variable region. See, the court has to see whether he is doing supervisory in nature or not.
That has not been seen.
My lord, in issue number 1, everything has been dealt.
No, we are not satisfied, Mr. Ratha. This is not a matter to be dealt in this casual manner.
My lord, some time
No.
time may be given. I'll
What
give-
time you will be taking?
My lord, I have.
You go and satisfy that.
My lord,
Mr. Ratha, you go through hundreds of decisions on this. There both parties must have laid evidence
my
with.
lord, I have laid the evidence.
Okay, then where is that discussion?
My lord, I have laid the evidence.
No, he has just, Mr. Ratha,
I-
you
I-
have to understand.
My lord, that
he-
issue
he
has
has
been dealt
just
by them.
given some legal propositions and laid his view.
My lord, I brought that evidence, my lord.
You have
Only-
brought us the evidence, so let him
No, no, I will-
scan the evidence
I'll
again.
file my lord that.
No, Mr. Ratha, the problem is that you are, because the more you read, you will be more
No,
disappointed.
my lord,
is the
evidence has
problem
been
also.
laid. Cross-examination has been made. I will brought that
No,
record.
that is there. We are not to take decision unless the tribunal takes a, or labor court takes a
My
decision.
lord,
on that.
material is always available. my lord.
Okay, right. We are
I'll
not
file
there
that
to take a decision.
I'll file
Ratha,
that
filing here-
sometime maybe.
Filing here will
Some
damage your
time
case.
maybe.
Mr. Do you appreciate Mr. Ratha?
Well,
You are supporting him. That though there was evidence, he has not disclosed or discussed.
my lord, he has discussed, my lord.
So kindly show that. So you don't fall into that trap.
Issue number
So
1.
that is the argument.
ये पेज 33 देखा तो कोर्ट से elicit कर ले सेटा.
My lord, I am pressing. my lord.
And don't argue against yourself
But-
that there was
but-
evidence
but-
and he has not discussed.
The issue related to whether second party
माइक रे रोन
Well.
माइक रे रोन तो.
second party is coming under the definition
Tripathi, please
of
address कर दे mic तक.
depend under section 2,
कोर्ट पढ़ुचंदी where are you
page 32, my lord. Issue
30.
number 1.
हाँ. Yes.
Defined as defined under section 2A of the ID Act or not. On this context emphatically stated that though the nomenclature of his job
पुणी अपन कुआड पळेलेनी. हाँ, emphatically stated that though nomenclature was to see
of his job was chief supervisor 1, he did not supervise the work of any
Subordinates.
or any subordinate, rather the nature of work, operational, clerical, manual. The second party, double number 1, during the question of clear term stated that he was operating a turbo generator. But this is crucial under the management. The second party claimed that he is a workman under the management for contract. It is argued on behalf of the management that since second party was supervisory staff and was drawing more than 10,000 per month, and so also power vested on him was mainly supervisory and managerial nature. There, please. He is not coming under the definition of workman. It is settled principle law that
So just stay here. This part now you are going to read. For your submission, this is observation of the court or this is the submission of the party?
party, madam.
Party.
Right.
Submission of party. Okay, read. So this is definitely submission of party.
Well,
Right.
the written pattern nature of duty of the concerned employee and some work incidental done by him in this connection, MW1, who is none other than the manager, their manager, my lord, of the management may be taken note wherein he stated in part 28 of his question that he could not say the nature of job of the operator. and the manager in which the steam turbine operates. Similarly, MW2 during cross-examination volunteered that present workman used to operate the work. This is crucial matter. They are cross-examination. Work on of the field operators, though computer system from the AC room. He also denied suggestion put by the second party that the workman used to job of the worker under the management. He was never placed in a managerial post and he was having no authority to sanction the leave of others or to supervise the work of others. That is my nature of it. MW number 3, during the evidence report that his nature of job, also nature of present workman was same as MW number 3 during cross-examination. At para 14 categorically stated that he used to perform shift duty of 8 hours duration, and the usual practice is that at the time of joining in the duty, the reliever used to brief about parameter orally. They used to maintain the logbook manually during the working period, but the same was later stored in a computer format. He further stated that he used to operate manually through a computer. He is also stated according to logbook instruction, they used to perform the duty. It is further stated by MW number 3, he has no authority to sanction leave contractual field operating working department. He further admitted that clause 13, Exhibit B, issued to the workman being guided by the standing order of the rules and same was struck off. In the case of such and such, it is held that workman doing so some supervisory work to the proved nature of a duty will not take him purview of the workman. So in absence of an evidence that the second party is being a supervisor operation, primarily doing supervisor of manager in nature head duty, it is held that the second party is a workman.
Where is the evidence? Is, one of you give the copy of evidence, management evidence, both sides. Yes, it is there available.
It is available.
Come
but
to
I
page,
can file it in a compilation. If your lordship permit me, I'll file it in a compilation.
Pardon?
I'll file it in a compilation. If your
That's there. Let us go to the evidence directly.
If your lordship will permit me, I can file it in a compilation.
You have filed a compilation.
No, I'll file it by way of a compilation. I'll file the evidence and everything in one compilation.
Oh, Annexure 8 is there.
Yes, my lord.
Whatever is available now, kindly go take the code through
Annexure
that.
8 is there.
Yes,
It's the affidavit of evidence on workman.
Yes, my lord.
What we find here is he has discussed on the evidence. And then taking a proposition of law comes to observation that yes, this is a work of workmen only. So therefore, how he has considered the evidence is material.
But there are two things here. He was appointed on contractual basis. His salary was more than 10,000 rupees. It was 9.
Salary is not always relevant. Type of work is always relevant.
Yes, my lord. I agree.
Salary, you may be some company, American company, they pay in dollars. So somebody may be paying $5,000 a month to a workman. That cannot take away the cap given in the Industrial Dispute Act. Salary under so and so, all salary holders are within so and so comes within the definition of workman. Cannot be. Some managers are also paid 5,000. So nature of work ultimately. Yes. Work was operational, clerical, manual job for the company. I am a workman as defined under section 2. See, is of oil. Following documents, office order through the documents also, he is attempting to establish that his nature of work is so and so. Now you come to your management evidence.
That's at
MW.
Page 89.
You have only one witness.
But I would like to go through that evidence of the workman. If your lordship will permit me, because there are many documents which.
That is there.
1314.
Achi.
Paragraph 1314 in that evidence at
No, my lord.
page.
There is a cross-examination also, which has been
Everything
filed
there.
at page 84.
Yeah.
Page 84 is the cross-examination. If your
It
lordships
is
are
there-
going into the,
It is there on record.
yes, my lord, it is
My
there
lord,
on
Page, which page you are
page
referring?
85. It starts
85.
cross-examination. So
85.
if your lordship will permit me, then I have to go into the cross. If your lordship is looking that,
No, where is the question of after commencing argument? You will say, I will go through, prepare. What is this?
no, my lord, I'm not
You know
preparing.
my time constraint.
No, I'm not seeking for time, my lord. I'm not seeking for time.
He wants to place it.
I'm not seeking for time. If your lordship are going through the evidence,
Yes, you have
then
to
I have
turn
to.
now. Your turn. You have to satisfy.
Yes,
Why
lord.
you seek permission? Yes, page 85.
Now, if your lordship will look at page 82, paragraph 13.
We have read it all.
My lord, I have to show paragraph 13 and 15.
Yes, it
Yes,
is
taken note of.
taken.
My last drawn salary was rupees 19,100.
Right. And
Although,
15, he says these are.
although I was designated, now your lordship will just read with me for a moment. Although I was designated as a supervisor, but the nature of my duties are neither managerial nor
We have
supervisory.
read that, Mr. Mishra. Before your placing, we have already read that.
Lord,
Later
your lordship will
paragraphs.
look at the second sentence. The nature of my work was operational, clerical, and manual. In the review order, your lordship have recorded the tripartite settlement which has been gone into, which is at page 72 of the writ petition. The tripartite settlement at page 72. If your lordship will look scope and coverage of that
He is the
settlement.
beneficiary of tripartite settlement.
No, he's not. That's why these are the persons who cannot, this shall not be applicable to the following. Other employees like clerical, supervisory officers and persons engaged on contractual basis. If your lordship will look at paragraph 2 of the page 72 terms of settlement. Your lordship has page 72.
Yes.
This is the terms of settlement. If your
Mr.
lordship will
Mishra,
look,
before that, you must satisfy us that this was a plea taken in the written statement.
sorry, my lord,
You must satisfy us that this
This was a plea in the written statement.
I'll just.
It was not there. You can't now go on adding
My lord,
additional material.
I have also filed my written submissions before the
Written
labor
statement,
court.
this pleading is not there.
Before the labor court, I have filed my written submissions also.
Written submission cannot improve. Now that is the Supreme Court guideline.
You come to the cross-examination,
48.
which you wanted to place,
Now,
84.
Supreme Court guideline yesterday
Yes, my lord.
regarding written note of submission.
He must
Yes,
be
You
aware.
can't incorporate anything beyond the pleadings, all
He is
documents.
a Supreme Court
He is a Supreme Court lawyer. You
No,
must
my
be aware.
My written submissions were
So
before,
therefore, please don't adventure.
my written submission was not before your lordship. It was before the labor court only.
That's right.
Yes.
Lordship is saying
Written
that only.
submission cannot. If it is applicable to High Court and Supreme Court, why it is not applicable to the Labor Court even?
You wanted to take to the cross-examination in 84.
Nothing, any evidence on this settlement will be just to be thrown out.
Lord,
So
could your
please
lordship
don't
just,
adventure.
just bear with me for a moment.
You are reading your written statement. We did not find any sort of submission there. Have evidence. Your chief also absolutely silent on this. So therefore, don't adventure on this. Yes, advance your any other submission.
Would your lordship just pass it over?
Pass
So
it
that
over.
I can come and, because I didn't look into this aspect at all, because we have taken this aspect in the writ
In the
petition.
middle of hearing, learned counsel appearing for the management for the time. Voilà. The matter to be listed in next assignment. You know, my time is running out, therefore I can't postpone this.
I
matters
understand.
in this way.
It was always a pleasure, but if your lordship can keep it, if your lordship can
have
keep it
your
tomorrow also, I'll appear.
You have your adventure in the next,
Lord, if your lordship also keep it tomorrow, I'll appear before.
next, sorry.
Item 11.
Very grateful.
Also come to next week.
Yes. Next matter. नहीं क्या होता है तब टाइम जो करो
Very grateful.
Item 11
After
on
long argument of half an hour. Yes, item 11, what is this? Is it a small matter?
item 11 on behalf of Mr. Patnaik. He's
You
suffering
want
from dengue.
adjournment?
Yes, your lordship. He's suffering from dengue, your lordship.
Huh?
He's suffering from dengue.
Dengue?
Yes, your lordship.
All right, matter is released from board.
Obliged.
Considering the council is unwell and suffering from dengue. Yes, interim order যদি কিছু থিবো extend হবে না?
Obliged, ma'am.
13.
Item 12.
How nova କିଛି matter. Achi, any settlement here?
Sir, item 12, I'm for the wife.
You are for the wife, no.
Divorce are allowed.
You are challenging divorce or allowing?
Allowing divorce.
Oh, judgment দরকার.
Not necessary, but I may humbly submit. It's there, all both of them are in old age. Both of them are in old age minors. Kind of a glance to the judgment about the quantum of permanent alimony.
So you confine it to quantum of.
Yes, exactly, minors, because of the fact that both of them are residing separately. Now this lady is
No possibility.
no possibility, minors. There's no
Quantum
possibility.
କଣ ଦେଲେ?
Quantum ଦେଇଛନ୍ତି only 2,30,000 ଟଙ୍କା.
On the premises?
That the petitioner who was serving as an employee in government, retired and getting pension 15,000. No more consideration of the gratuity and all these things. And 15,000 and two months back remains.
Then if we go to enhance.
May I submit minutes? Till minutes as on date. I should not blame my fraternity. No petition filed for interim maintenance or anything else. Not a single pie has received shares from the husband towards maintenance.
Yes, you volunteer.
My lord.
You volunteer, what should be the amount justifying?
But it was settled in.
ये माइक रे कोन तो आगे लेखा आला ता सत्तो इम्प्रूवमेंट होनी प्रति
Mosquitoes will be more in this side, less in that side. You are safe from dengue.
You are in large number, but we are in very reduced number. So that survival of this is more important.
The Aedes mosquito is now, at least I have seen some mosquitoes. So in that side, there no mosquitoes are there.
No.
And today, 2 adjournments for dengue.
Dengue.
And that is also coming to rescue of the lawyers also.
So therefore, and my house staffs are also suffering.
No, this fact minors in city areas and all these minors. So that's now spreading.
now a very strange thing coming up. People reside outside state.
Yes.
Orissa state, because nowadays volunteer 3 times or 4 times कौन दे परिवे
ମୁଁ instruction ନେଲେ ଭଲ
ହାଁ?
I will take instruction Lord.
ଆପଣ କାହିଁ ଟିକେ ଆଗରୁ ଏ ବିଷୟଟା ଆପଣଙ୍କ ସ୍ତ୍ରୀ ତ ସିଏ
ନାଇଁ
ସିଏ
actually
ଡାଇଭର୍ସ ଆଉ ଚ୍ୟାଲେଞ୍ଜ କରୁନାହାନ୍ତି ମାନେ ଆପଣଙ୍କୁ ପ୍ରପର୍ଟି ଷ୍ଟେଟମେଣ୍ଟ
my lord
ଆଣ୍ଡ ଦି ପାସବୁକ୍ ପର୍ସେଣ୍ଟ
my lord my lord.
ନେହା ରଜନୀଶରେ ଦିଅନ୍ତୁ ଆମେ ଡିସାଇଡ୍ କରିଦେବୁ କଣ
ଆଜ୍ଞା।
ଟଙ୍କା ସେ ପାଇବେ He's had the appeal is confined for the submission of Sri Mahapatra, the appeal stands confined to quantum aspect only. Taking this court to the stake in the livelihood of the old lady being the appellant here. Government employee. Also in enjoyment of pension, regular pension to his pocket. There is claim for enhancement of the permanent alimony only. On the counsel for the respondent being asked what should be the appropriate permanent alimony for survival of a person of this, of a lady of the age as per the cost rate. Counsel, Sri Mahapatra, learned counsel for the respondent, takes this court to the reasoning assigned in coming to such conclusion. For the appeal confined to only enhancement in the permanent alimony, this court find it appropriate to consider question of permanent alimony, but keeping in view the judgment in of the Hon'Ble Appeals Court in Rajneesh versus Neha, and also a judgment of this court. ଏବେ 4 दिन ତଳେ judgment ଟା ଶୁକ୍ରବାର ଦିଆ ହେଇଛି ହେଲା ପଚାର ଦବେ ମାନଙ୍କୁ 42 44 pages ର judgment ହେଇଛି ଆମେ ସେଥିରେ principle ପୁରା jot down କରିଦେଇଛୁ. Court direct the respondent to bring in property statement of himself and also of his parents, if any. Further also, income through statement on income through any other sources, while also producing the pension certificate last month. In the pay slip दिया होती सेंतो द pension certificate आसुतो of at least of last 3 months. Hello, last 3 months available. Last month thibo no thibo. Hello. By Monday, let the petitioner appellant also bring.
I don't have anything.
अरे तांकर कौन थिला आपण स्त्री जानि नथिबे कौन थिला बोली
You have an option, and also you have option to reply to his affidavit.
दे आज्ञा मु थिला बेले देखि जी संपत्ति किनिथिले बहु करथिले निकी करथिले से जजमेंट पढों आम जजमेंट टा पढिबे आम बेंच रो जजमेंट टा पढिबे आम समराइज करछु व्हाट आर द कंपोनेंट्स required to be taken into account.
Yes.
6 components we have taken very seriously and enhance the compensation accordingly. आउ नाही वर्तमान जे कोनसी compensation आसीबो खाली सेही फॉर्मूला पकेइबो डिसाइड करिवो एंड एफिडेविट आउ किछि नाही
बढ़िया
also by Monday he brings his affidavit on the
objective method as well.
property of husband. Two things we make it clear. The judgment has made it clear.
Yes.
Living standard up to the standard of husband.
Yes.
Number 2, property residing in her parents' house is immaterial. Income income of her parents remain immaterial. While enhancing the compensation, the ailing aspect or health aspect is also to be kept in mind. So से 2,50,000 30,000 से कहि दियंतु जे इथुरु से केते टका ता हेल्थ पई करिवो केते टका घर भड़ा पई करिवो ताको लग्जरी रे रहिबा पई तेनु आपण जो एफिडेविट फाइल करिवे से केते महला घरे रहउचंती को शहर रे रहउचंती ଆପଣ ଘରଟେ ଭଡା ନେଲେ ସେ ସହରରେ କେତେ ଯଦି ଭଡା ଘରେ ରହିଛନ୍ତି କେତେ ଟଙ୍କା ଦଉଛନ୍ତି very relevant now.
Your lordship may keep it next week so that I can take instructions
Mr.
from my
Mahapatra
clerk.
actually say, also you have to, I'm only supplementing my learned brother. That you said that there is a good ground for divorce and that judgment doesn't say that in these cases of granting of divorce, the alimony will be less.
No, that is not my
So,
submission, Your
so,
Lordship. That is not-
and here, that particular paragraph is there.
My lord.
That see, they are separating after a marriage of about 20 years.
20
Yes.
years.
So
And
that would
is
be a
a condition.
relevant, that is a
That
condition.
is also a ground there. Period of staying together is also taken into account and then separation.
Yes.
20 ବର୍ଷ ରହିଲା ପରେ ସେ ଆଉ ବାହା ହେଇପାରିବନି. That is also to be kept in account. So it's not mere maintenance. ତାହେଲେ ଆପଣ କଣ ଚାହୁଁଛନ୍ତି ସେ ଯାଇ ଜଗନ୍ନାଥ ମନ୍ଦିର ଆଗରେ ବସିକିରି ଥାଳି ଧରି ବସିବେ ଆପଣଙ୍କ ସ୍ତ୍ରୀ ଡାଇଭର୍ସ ହେଇଯାଇଛି, that's a different thing. ଡାଇଭର୍ସ ହେଇଛି, marriage is not
No,
disputed.
for
Divorce is
actually
on certain ground.
what has happened, my lord, Your Lordship may.
ଆଉ argument ନାହିଁ, ଆପଣ ସବୁ ନେଇ ଆସନ୍ତୁ, ଆଣି ସାରିଲା ପରେ it is still open.
My lord.
If you volunteer to bring it to 10 lakhs, volunteer 10 lakhs, ଆଣନ୍ତୁ 5 ଲକ୍ଷ ଆଣିକି ଟଙ୍କା ଥୁଅନ୍ତୁ, କହିବେ 10 ଲକ୍ଷ, we may give you some installment. If it is 3 times.
ସେ ଆଜ୍ଞା ଯୋଉ ଆପଣ ସେ ବହୁତ ଖରାପ ଲୋକ ଥିଲେ ଆପଣ ପ୍ରୁଭ କରିକି ଡିଭୋର୍ସ ନେଲେ, that's not a relevant
No,
for
that is not-
granting it. So
No,
ଆପଣ
that is-
କଣ କହିବେ? ଆଉ
It
କହିବେ
was
ବହୁତ
settled-
ଭଲ ଲୋକ ଥିଲେ,
It was
give
settled-
more.
Society
was-
ରେ ବଦନାମ କରି ଛାଡି ସାରିଲେ.
It was settled for 1,30,000 before the women's commission.
ସେଟଲ କୋଉଠି ହେଲା ଆଜ୍ଞା? ସେଟଲ ହେଲେ ଆମେ କଣ ତାଙ୍କୁ କହିଦବୁ କି ଆପଣ କିଛି ନେବେନି ବୋଲି?
No, ସେ ହେଇଥିଲା।
ଆପଣ agree କରିପାରନ୍ତି, ସେମିତି ଗୋଟେ petition file
ତାପରେ subsequently it was
Agree
enhanced to
କରନ୍ତୁ,
2,30,000.
that was withdrawn. That creates a bad precedent.
Place the matter on Wednesday. Next Wednesday ଆସିବ, ଆଜି Wednesday ହେଲା, ଭଲ କିନା ଭାବି ଚିନ୍ତି କି you don't file a formal affidavit, go through that judgment.
Yes, Your Lordship.
ହେଲା ସେ judgment ର ଯୋଉ relevant ପାରାରେ ସେ କହିଛନ୍ତି କୋଉ କୋଉ ଜିନିଷ consider ହବ, ଆମେ ବି ଆମ judgment ରେ କହିଦେଇଛୁ ଏଇ ପାରାରେ ସେ relevant ଅଛି, ଆମେ we have also classified those items specifically.
We'll
So
go through.
file in terms of that.
We'll go through.
ଆମେ ଏଠି decide କରିଦବୁ, and you may also take support.
Yes,
ଶୁଣନ୍ତୁ,
ma'am.
ଆପଣଙ୍କର ଆଜିକାଲି variety of measures ଆସିଗଲାଣି.
Yeah.
Supreme Court କହିଲେଣି,
Yeah.
Supreme Court in the minimum wages ରେ
Yes.
or even accident claim ରେ where component of salary is not available.
Yes.
What should be the minimum component
Correct.
to be taken into account for survival of a person?
Correct.
So many things are there. ଆଣନ୍ତୁ, ଆମକୁ ଦିଅନ୍ତୁ, ଆମକୁ ଗୋଟେ opportunity ଦେଲେ ଆମେ will deliver a judgment. ଠିକ ଅଛି, ସେତିକି ହେଲା ଆଜି। ଇଏ 13, 14 ଏଗୁଡାକ 22 ମ୍ୟାଟର ଅଛି and 23 ର ମ୍ୟାଟର ବି ଅଛି ଗୋଟେ, ଇଏ ସବୁ ରିଲିଜ ହେଇଗଲା। ଯୋଉଠି ଇଣ୍ଟ୍ରି ମର୍ଡର ଥିବ ଇଣ୍ଟ୍ରି ମର୍ଡର କଣ୍ଟିନ୍ୟୁ କରିଦବ।
ମାନେ 14 ଟା ମାନେ
13, 14 and
14 ଟା ମାନେ
15.
just order of reference
pardon?
14 item ଟା order of reference ର schedule correction ପାଇଁ amendment ପାଇଁ ଅଛି।
Order of
reference ର schedule କୁ ଚ୍ୟାଲେଞ୍ଜ କରିକି amendment ଦେଇଥିଲେ ହେଇନଥିଲା।
ହଁ ହେଲା, କଣ ହେଲା ଶୁଣାଣି ତ ହବ, ଶୁଣାଣି ହବ ନା ନାଇଁ?
amendment ହଁ, yes
ଆପଣ ୱାର୍କମ୍ୟାନ ପାଇଁ କି?
yes
ଓ ୟୁ ଆର୍ ସଫରିଂ।
yes
14
status quo
ଆଣିବା ଆର ସପ୍ତାହ ଦେଖିବା। All right, next Wednesday 14 ଟା next Wednesday ଆଣ। ଆପଣଙ୍କ ନାଁ ତ କାହିଁ ବାହାରୁନି
ମାନେ is there ମାନେ
ଏଥିରେ, କେବଳ ଏଇଟା ୱାର୍କମ୍ୟାନ ଚ୍ୟାଲେଞ୍ଜ କରିଛି ଅର୍ଡର। କଣ ହେଲା insufficiency?
my lord, the schedule in the order of reference,
ଦେଖେଇଲେ
the
14
schedule
ଟା
in the
just
order of
1
reference.
minute. 20237 yes.
My lord, the schedule in the order of reference was not reflecting the actual lease between the parties.
Just 1 minute. Where do you find the reference?
Reference is at 15 and
Page
annexure 15, page my lord,
66.
yes, my lord, 66. Annexure 15 series and one corriendum is also there.
Huh?
Amendment, after amendment, one corriendum is also there because I submitted my amendment to the appropriate
Where is the
government,
corrigendum?
state,
Oh, corrigendum is page 68.
66, 68, yes, my lord.
66 is the reference.
Reference, my lord.
68 is the corrigendum.
Yes, my lord.
So spelling the correction.
I
correct.
submitted my repentation
Now,
before the
how are you
appropriate
agreed by
government.
this reference?
My lord.
How are you agreed by this reference?
Yes, my lord. The schedule of the reference.
Oh, how are you agreed?
I am aggrieved. कौन भूलटा ହେଇଛି ସେଟା କହନ୍ତୁ sir. Yes, ଖାଲି madam. schedule
I am
set
aggrieved
on the 4 points. On 4 points. One is
Where is,
that
where
my
is-
name was.
where is your representation to the labor authority?
Yes, my lord. My next to 14.
14.
54.
Management को notice ହେଇଛି.
ସେଟା ଆପଣଙ୍କ amendment ଟା amendment schedule original ଯୋଉଟା ଦେଇଥିଲେ ଯୋଉଟା କି ବାହାରିଲା. So my lord, I have annexed. ଆପଣ ଯୋଉଟା complaint petition is annexed. 14. Sir, ଆପଣଙ୍କର annexure 14 is post publication of the schedule. Lordship
that
is
is not.
asking you to show what was your first
Request.
representation.
Original request.
My representation to the appropriate state for amendment in the schedule is at. ସେଟା କହିଲେ ଚାର ଥର କୁହନ୍ତୁନି. Where is your representation that led to the schedule? Publication of the schedule. Where is that? It is a reference matter, my lord. It is-
Oh, it's a reference based on a representation or
Yes,
not?
my lord.
It's not a 2A proceeding.
Complaint is
It
there.
is 10-1 proceeding.
Yes, my lord.
So reference is always based on a claim by the, put up by the workman to the labor
I
officer.
submitted my complaint. It is there before the DLO. The complaint is there, my lord. Annexure 5, page number 35.
Annexure 5 page
Number 35.
35.
I submitted my complaint before the DLO
It
and
is always
cancellation was
submitted.
held. And after submission of the cancellation failure report, this
Complaint
reference.
ହଉଛି complaint ଟା ଆପଣଙ୍କର ହେଲା non payment of my monthly due salaries for the month of January 19
Yes.
and then from March 19.
Yes, ma'am.
So that was, what was your prayer there?
There that to prayer therefore under the facts circumstances stated above, I earnest
Non-payment of
5 and 6 पढ़ନ୍ତୁ. 5 and 6 page 36 last paragraph 5. 36. That however I have been still continuing in service in the office till
all
today
non-payment of monthly salary.
and the authorities denied me doing the work. So in fact, though you have not stated regarding denial of work, still they have framed the issue in your favor. No, my termination.
That is
My lord, when I
enlarging
was
rather.
continuing, I filed my complaint. Why you are presuming that the court is not following? You have to interact with the court. I'm submitting that during conciliation I was
Sir, after
listening to you or posing you something. No, my lord. You have to understand and answer that. Yes, ma'am. So this reference has enlarged your
It
grievance.
is rather in the betterment of the workman.
Where you are agreed for which particular aspect you are agreed upon କହୁନାହାନ୍ତି. ମୁଁ କହୁଛି ଆଜ୍ଞା ମୋର କହନ୍ତୁ straight away come to that. So reference ରେ actually ଆପଣ କଣ include ହେବାକୁ ଚାହୁଁଛନ୍ତି ନା delete ହେବା ପାଇଁ ଚାହୁଁଛନ୍ତି? ନାଇଁ my lord ମୋ ନାଁଟା ଭୁଲ ଥିଲା spelling.
ସେଇଟା ତ ହେଇଗଲା.
That is
Forget that.
corrected. Then the second was I applied on the amendment the representation that my designation was office attendant. I was appointed as office attendant.
Don't argue on merit. See, you have clear pleading in para 4 and 5, like my brother said. Come to para 4 and 5.
4 and 5 of the petition. ଯୋଉଟା ପଢୁଥିଲେ ଏବେ
Para 4 and
ଆପଣଙ୍କର
5 page
ଯୋଉଟାରେ
36.
what you are reading your representation to the labor authority. Page 36.
Page 36, 4 and 5 पढ़ो. Therefore, it will be just whether the reference is justified or not. It is to the benefit of the party. You are unnecessarily challenging that. Our opinion.
My lord,
Read 4 and 5. Read 4 and 5.
4. That on dated 27/7, I received letter by number 1532 by and dated 17/7/2020 along with annexure 2 numbers of letters by this letter number then another letter number of the service provider wherein the additional secretary to government director CAD's PIM has categorically denied my engagement in service since 13/12.
So have a pause there.
My
So you have a categoric plea that there has been stoppage of your employment. Leading to non-payment. You say this non-payment is having a foundation of non-engagement.
No.
So therefore it is in the larger interest of the workman.
My lord.
A issue can very well be framed there on the schedule of reference. If yes, you must be finding every issue framed in the industrial adjudication. If the termination is illegal, then they write usually, if yes, what benefit?
What relief can?
So that benefit will take care of. Suppose the termination or
Well, date of-
disengagement is
date
found
of-
to be illegal.
Date of termination is wrong. That is also another point.
Date of termination,
Is wrong. My designation office attendant is not there. And date of termination is not there. And principal employer is not added.
କରିବେ ଯେ କିନ୍ତୁ କଣ ହବ କି limit କରିଦବ ଯଦି termination date ଟା proper-
Minor correction. କେବେଠୁ termination ହେଇଛି ବୋଲି କହୁଛନ୍ତି? According to you?
31/12
During conciliation, they dissented me.
During ଆପଣ କୋଉ date ରୁ ଚାହୁଁଛନ୍ତି ଏଇଟା ହବା ପାଇଁ?
Yes, I submitted my form M. That is at page
Come
number.
back again to that para.
Submitted the statutory form M. That is
Come back
annexure
again to that para.
1249.
Denied my service, my engagement in service since dated 31/12/18. Which is totally false, baseless. Now you may say the schedule having kept the termination date as 1/4/19 may be creating prejudice to your interest.
My lord.
Yes, what is there, then it has to be corrected.
Lordship, it can be adjudicated there itself.
No, the difficulty of the industrial adjudicator is, he is to straightway go from the reference.
Yes.
Reference once put a date. He can't go beyond that.
However, he has not produced any document to show that he was in
Yes,
fact.
he has a proper pleading on the
This
basis of
pleading he
which
has produced a
the
lordship.
reference has come.
Lordship.
So therefore, if the industrial adjudication is allowed to proceed,
My lordship.
then he can't get protection from this date 31/12/18.
Lordship. Only the date may be corrected.
So
then.
that date has to be corrected.
That I don't have any.
So therefore,
hesitation, Lordship.
there is necessity of consideration of the reference itself.
Yes.
On the, and it has to be, a decision has to be taken on the basis of his claim.
Lordship.
Ultimately, tribunal, what the tribunal will do, we are not bothered. Even labor officer should not also be bothering himself. But the reference must be in the light of the claim.
My lords.
And one may think for a while, management might have put a response saying that no, termination is from not this date, from such and such date. That is also not coming here. If you have the copy of the management response to this.
My lord, I am submitting a date chart wherein the principal
No,
employer says-
from amongst the documents in the read petition. Read petition re ଅଛି କି ଦେଖାନ୍ତୁ ତାଙ୍କ response ଟା to your claim. Labor officer normally put the management to have a claim.
No, my lord, conciliation failure report re ସବୁ ଲେଖା ହେଇଛି. Everything is there. in the
Conciliation failure report କାଇଁ?
failure report is there at conciliation failure report. I have attached.
Yes, 52.
Yes, my lord.
Come to page 52.
52. I have enclosed the conciliation failure, but
Yes, page 52 you find.
and 53.
Report under section 12(4). This is conciliation report. ଆପଣ brief ରେ bound page
It's there, your lordship, page 50.
ସେ କିନ୍ ପାଉନାହାନ୍ତି
My lord, is there?
ଆପଣ page bound ପାଇଲେ?
Yes, my lord.
That is, come to the grievance of the workman clause.
Given for the workman.
Office attendant deployed by
ତା ପୂର୍ବରୁ ଟିକେ ଦେଖନ୍ତୁ your complaint petition first line. Complaint petition is 27,820. Let us see what is this. This is 27,820. So therefore, he is taking this application into consideration. Whatever he writes, we don't bother. Now, what he writes of the management, views of management. Management is remain absent on the date fixed. Management admittedly submitted engagement of the workman so and so. On February 2019, the workman was absconded. Management admittedly submitted engagement of the workman with effect from 1/5/2013 in the office of chief so and so, department so and so, till January 2019. So, 1419 देले से ठीक अछि एठी जे जनवरी till January 2019 ये कहउछथि मोर 31 डिसेंबर परे मोर एंगेजमेंट आ नाही से 31 टा आसीबा कथा
Maloj.
so therefore not in terms of management responsive in.
So my lord, my form M.
All right.
Form M.
Had the
Only on that point, your lordship. Only on the date aspect.
only on the date aspect.
Lordship.
No. See, we are not framing a schedule here.
Lordship.
We leave it
My lordship.
to the discretion of the labor authority to bring out a reference strictly in terms of the claim of the petitioner.
Lordship.
Sethi question asipare. So the one thing might be playing in your mind. You are not management. You don't bother for those things even. You are only state only giving a reference. Tapare your matter is going out of your hand. The management is to understand. There may be a doubt or dispute. Kintu jodi gote earlier date thiba, then there is escape to the workman, escape to the management also. Benefit can be redrawn from a subsequent date. But suppose a cut-off date is already given, benefit is to follow or flow from a prior date that cannot be given by the labor authority. ଆପଣ ପ୍ରେୟାର ରେ କଣ କରିଛନ୍ତି? ପ୍ରେୟାର ରେ କଣ କରିଛନ୍ତି? Okay, subsequent corrigendum is ସବୁ ଚାଲିଯିବ in the light of all right. If the reference goes, then the proceeding is already commenced. Proceeding already commenced.
It is understood.
It is registered as ID.
Yes, sir.
So that proceeding has to go.
My lord.
All right.
So my lord, I have submitted form M because during conciliation I was disengaged. I formed the statutory.
We have
form M.
understood your proposition.
That must be considered, my lord. Form M.
Had the submission of it is why management has not done. Management was given notice.
Yes, notice has been issued, your lordship.
Notice
On
was
17/8.
issued. And what happened on the management? AD received from it after valid service, right? Okay, all right. I had the submission of the counsel for the petitioner, the workman, and the state being the competent authority involved in the reference of the in the reference NSO 15 brought under the industrial adjudication in ID case number
38 of
what a sleeper lekhi de diyon.
My lord, it is there. I have
Sleeper lekhi de diyon to.
My lord.
An ID case number so and so. Okay. Factual background appearing main thrust of challenge in the writ application appears to be is involving NSO 15 a reference by labor and ESI department Government of Orissa on the premises that the reference made therein is contrary to the plea and contentions of the workmen and also not in terms of the plea taken by the workmen in the complaint submitted before the labor authority by Annexure 5. You are Mr. Tripathi. Mr. Tripathi, learned counsel appearing for the workmen taking this court to the plea taken in the complaint petition by Annexure 5, particularly reading through para 4 and 5. Reading together with the prayer therein, at this time, a point of time, taking also this court to the reference made to the Industrial Authority for Industrial Adjudication by Annexure 15, attempted to establish that the schedule made therein, the reference made therein is not in strict terms of the complaint of the workmen by Annexure 5. It is keeping the, it is on the above premises, Sri Tripathi learned counsel submits unless the reference is corrected, amended suitably in terms of the corrected criteria, amended suitably in terms of the claim of the workmen herein. There is serious prejudice to the workmen in as much as there will be undoubtedly landing in the refusal of entitlement of the just claim made in the complaint application. Sri Sonok Mishra, learned counsel appearing for the state, representing the reference authority, however, in reference to the counter affidavit. In addition to the grounds taken in the counter affidavit, contains for the proceeding is pending adjudication of the industrial adjudicator. The industrial adjudicator may not be precluded from getting it to the actual complaint involved herein. In this circumstance, there is an attempt to block the writ petition herein. Considering the rival contentions of the parties, question required to this court find the question required here to be decided as to whether the reference by Annexure 15 is in terms of complaint of the complainant by Annexure 5 question mark. Further, if further, since a reference is already made, if the industrial adjudicator has any scope to go behind or beyond the reference involved herein, it is keeping the above question in view and the plea of the parties, this court on perusal of the brief finds the reference has a foundation through Annexure 5, a complaint on behalf of the complainant, the workman herein. The complaint appears to have been submitted to the district labor officer on 27/8/2020. Judgment of. Complaint paragraph 4 and 5 has this specific following pleading.
Page 36.
Page 36. Quote karna, page 36 of quote. Further, the complaint also involved the following prayer, page 37. Based on such complaint, it appears there has been submission of a failure report as required under section 14. Yes, a failure report annexure.
Failure
ପଢୁଥିଲେ,
report,
ଏବେ ଆମେ ପଢୁଥିଲେ
failure report. Annexure
Page 52, your lordship.
page 82.
52.
52,
Okay, that come by way of rejoinder. Okay.
13, annexure.
Page
13, page 51 to 56.
52. So that is in part of the deed.
Annexure 13.
Yes, 13. Right, annexure, okay, should a provision the lecture. Section 14 dash. 52, na? Yes. Section 12, bracket 4 of the Industrial Dispute Act 1947 has a clear reference of this failure report has a clear reference of considering the complaint petition of the workman here dated 27/8/22. The failure report while disclosing the grievance of the workman taken down from the complaint of the petitioner dated 27/8/2020, however, has a clear observation that the management remain absent on the date fixed for discussion and inquiry. However, the further observation in the failure report, there is clear observation of the clear recording of the stand of the management brought before such authorities. It is this court in perusal of the failure report finds there has been already discussion on the claim and the counter of the respective parties there. And for there is failure in arriving at a conciliation between the workmen and the management, the conciliating officer was constrained to refer the matter, constrained to recommend for industrial adjudication of the proceeding. In the process, this court find there has been reference by Annexure 15, running page 66 of the brief, which of course has been subsequently amended by and notified by way of corrigendum as appearing at page 68 of the brief by simply correcting the name of the workman therein. It is now coming to decide issue number 1 in the above background, coming to decide the question number 1 framed herein. This court, reading through the claim of the petitioner, a workman, a petitioner workman here, through para 4 and 5, taken note herein above, along with prayer, also taken note herein above, finds the workman has a clear case of denying engagement by the employer since 31/12/2018. On the perusal of the plea of the management through the failure report page 53, on the under the heading views of management, this court find the conciliating officer has recorded the stand of the management. The petitioner workmen continued in service till January 2019 and remain absconded from
Page 53.
page. The date would check karibe setu hala page 53 ru. Okay. And remain absconded from duty from February 2019. This court therefore observes this court in the circumstance taking into account the contention and the rival contention as recorded herein also find place in the complaint as well as the failure report finds when the workman claims there has been this illegal disengagement with effect from 31/12/2018. Management, on the other hand, claims there has been absconding of the workmen since February 2019.
Served till January 19.
And served till January 2019.
SCR DAD.
Okay.
Serving in High Court.
Okay. This court find unless the reference include if the reference include the claim of the petitioner of illegal disengagement from 31st December 2018, there is possibility of consideration of the case of the management through their stand before the labor authority on the absconding of the employee or workman from February 2019. The claim of in the process, there will be inclusion of the claim of there is possibility of inclusion of the claim, inclusion and consideration of the claim of the management. If it is vice versa, it will be difficult on the part of the industrial adjudicator to consider the claim of the workman behind February 2019. In the circumstance, this court feels it appropriate, there should be a reference in the inclusion of the claim of the workman by altering the reference by Daniel 15, only bringing in the change in the date with effect from 1/4/2019 to 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 31st December 2018. Okay, in the circumstance, this court find there is in fact difficulty in undertaking the industrial adjudication presently by the workman. In the process, this court interfering in the schedule, in the order of reference by Daniel 15, to the extent, limited extent indicated herein above, remit the matter back to the Labour and ESI Department, Odisha government, for bringing out a fresh reference for industrial adjudication of the proceeding involved herein at the instance of the workman. Okay, as an outcome of interference in the reference at answer, okay, it is answer for is coming to the issue. Question number 1 is answered accordingly. Okay, for the detailed discussion in answering the question number 1, this court has already observed the limitations in the Working of the industrial adjudicator in case of reference already made. It is in this view of the matter, this court answered this issue in favor of the petitioner answering. Once a reference is made for industrial adjudication, the industrial adjudicator is precluded either going behind this order of reference or going beyond the order of reference. As an outcome on issue number 1, as this court has already interfered in the order at annexure 15 to the limited extent indicated herein above, the industrial proceeding by ID case number so and so 38 is also
of
declared
21.
bad, and the industrial adjudicator is free from undertaking any industrial adjudication presently. Okay, if a reference is made, then he is bound to take. We don't need any.
But my form M is to be considered by the state, appropriate state. My
But-
form M.
Mhm.
I submitted my form M.
Pardon?
ବୁଝିହଉନି ଆପଣ କଣ କହୁଛନ୍ତି?
My lord, during conciliation, I was not allowed
No,
to
no,
enter
sir.
into.
How come ଦରକାର ଆଉ ତ ସେ reference ଟା correct ହେଇକି
Form M I submitted,
form em ଛାଡ଼ନ୍ତୁ.
statutory form.
The fresh reference may be brought at least within a period of 1 month from the date of communication of order
A specific time.
of the judgment hearing. ବାକି ସବୁ ହେଇପାରିବ ସେଇଟା ଆସିଲା ପରେ ଆପଣ statement of claim ଗୋଟେ ଦେବେ.
Frame color.
ହଁ,
I can
statement
put
of
it.
claim ରେ
Yes,
written
ma'am.
statement. Before parting with the judgment, this court clarifies observation, if any, made herein above is only for the limited purpose and has nothing to do with the industrial adjudicators. Proposed industrial adjudication. The repetition succeeds, no cost. Yes. Thank you.
Item number 44. In fact, I am since last 3 days I am.
କିଛି ଶୁଭିବନି କାଚ ବାହାରେ ସବୁ.
Item number 44.
ଦେଖିବା ପଢୁ. ଅଛି there are some cover matters. He said 44 is.
Infructuous ହେଇଗଲାଣି କାହିଁକି?
No, they.
So all right,
File an affidavit.
let it is.
In that
File,
Quarrel
but
at
that
this-
municipal welfare.
No quarrel at this point of time. Yes. Yes, item 1, this is 2020 matter.
My lord.
Then
My lord,
why
only
it is pending
simple
so
there
long?
is that in spite of the direction this Hon'Ble court, my lord. When the order was produced for the collector, my lord, the order was the order was rejected. The prayer of the petitioner was rejected. Even if I have filed the annexure 1 or 2, may kindly have a glance over annexure 2.
No, your prayer is to exchange the permission to exchange the land.
My lord. Only, my lord, there is
Then why
no
this
objection.
petition is kept pending here?
Only
That has
direction.
already been rejected. The
That has
collector has rejected.
Rejected.
Yes, Tahsildar had recommended.
Huh.
He has given his reasonings. Your Lordship may kindly see the order dated 17/9/2029. Sorry, that is subsequent order.
My
The-
lord,
the-
running
they have
page 15, my lord,
15.
Yes.
15 of my petition.
Yes, please,
See-
one of you read.
Yes, seen the order dated so and so of Tahsildar Noyagad, wherein he has recommended for exchange of government land with private land as per provision contained under section 22A of OLR Act, gone through the case record as well as the provision of OLR Act under section
Where are you
22A.
reading? Page 15.
My lord, running page 15.
Yes.
The Tahsildar Noyagad has not properly gone through the provision. The provision under section 22A clearly envisages on surrender or abandonment of land by Rayat or tenant. There is no specific provision for exchange of land in OLR Act. Hence, the exchange of land between government and Prajapita Brahmakumari Ishwara Vishwavidyalaya Noyagad branch is rejected.
Right, you could have applied under OGLS.
Yes.
My lord,
You could have applied under OGLS. How are you applying under OLR?
my lord, so far the circular is concerned, my lord, it has been clarified. My lord, as per the circular, my lord, kindly have in annexure 2.
Yes.
There is a government circular that if it is a spiritual organization and they want to exchange, the same can be carried out.
No, annexure 2 here I am finding it's a order in OLR proceeding.
Yes, my lord.
Yes.
My lord, running page 10, last, last 4 line.
Yes.
This being a public spiritual organization as per the GO number such as such dated at the of the revenue department, the access can be allowed by the government to the same public interest.
There is no issue. There is no issue that government cannot allow.
My lord,
Question is which government should allow? Which establishment should allow?
the
Under
first,
the OLR provisions or under the OGLS provisions?
my lord,
You apply under OGLS, who prevents you? Why are you waiting for an order of the court?
no, my lord, earlier my lordship was pleased to direct this Tahsildar to dispose of the same.
Where
This
is
same
the
budget-
direction?
My lord, that is the WPC 16479 of
Now
2000.
he has taken a decision. It's
Yes.
not permissible under OLR Act.
It is
Now
permissible, my lord.
possible. So what do you find? You will pursue the remedy elsewhere or you will take a rejection order here?
No, I will pursue, my lord.
Yes, line counsel for the petitioner wants to not pressing the matter in order to pursue the appropriate government in terms of GO number 24256 oblique R dated 28/5/94 of the Revenue Department is permitted to be done, however, with liberty. এই মোর এই বেঞ্চের লিস্টটা কাহিনী ও এটা আছে অলরাইট I got it.
I don't know to.
Your Lordship. So the Commissioner Land Record and Settlement has passed an order without giving an opportunity of hearing, without our presence and no notice we have received
You
actually.
are a party to the proceeding.
Yes, Your Lordship.
Impugned order annexure.
Annexure, Your Lordship, Annexure 10, Your Lordship, running page 56.
58.
56, operative portion starts from, comments from 58, Your Lordship.
You are opposite party.
Opposite party, Your Lordship, Mangoli Malik and another.
Now there, what is your position? Mongoli Malik and another opposite party.
Your Lordship.
But here the parties are.
Again, we are the legal heirs.
Para 2 of the is clear. Para 2 of the impugned.
You are the legal heirs.
Your Lordship.
That means your predecessors have been allowed
Your
to
Lordship.
participate.
Your Lordship.
Then there is no question. You have to step into shoe of the legal heirs, say the predecessors. You have to step into the shoe of the, not that all generations will be given permission or opportunity. What do you want?
But again, actually no notice was received by us, neither by the predecessors also. Neither by the predecessors also, Your Lordship.
You are not a party at all.
Your Lordship, we are not a party, but our predecessors have also not received the notice.
Therefore, how can you be, your predecessors issued notice, where is that ground?
Ground, Your Lordship, I haven't.
Come to the read petition, where have you taken that ground?
No, Your Lordship, I haven't taken
Then
that.
why are you arguing
Lordship,
on a
I
ground,
may-
withdraw and bring a better writ application? Petitioner wants to withdraw the writ petition in order to bring better writ application. And you know, if the legal heirs will come, then a leave must be there. You are not a party at all in the lower court proceeding. किसी देखो ना दी सीधा घूस बात से फाइल कर दो जल्दी. Yes.
Item number 3.
500 टंका देगिरी भलो से. Yes, item 3.
My lordship, I'm seeking one passover, my lordship.
Pardon?
I'm seeking for passover, my lordship.
Passover.
Yes, my lordship. This is that secretariat entry pass matter, my lordship.
We have filed our counter, your lordship.
Your file counter
That-
this needs finally.
We have already rejected his application, lordship. May see,
Earlier notice was issued.
notice was issued, your lordship.
Direction and instruction.
We had only taken instruction,
Oh, that one.
my lords. Lordship, may kindly take page 21.
No, he's seeking Passover.
Actually, they have filed an application for amendment. That copy we have not received. Let them serve us. Because after this development, they have come up with an amendment. Let them serve the copy. Let it be taken up next week.
There has been filing of amendment application IE 12971 of 23 State Council objects non-service of copy of the same. Let a copy of the amendment application be served on the State Council. Okay, so council to argue not available. Adjournment is sought for. Matter posted to next Thursday, next Wednesday.
Lordship.
Not my lordship.
Item 4.
Please, my lord. I'm appearing through VC, my lord.
Yes.
My
Yes.
lord, very,
Panigrahi.
my lord. Very limited prayer, my lord. Annexure 6 before OP number 2 is pending, my lord. I have ventilated my grievance.
Annexure 6 page.
Page 38, running page 38.
Prayer for undisputedly on the self same issue. Application at the instance of the petitioner by the annexure 6 sent through registered post. Speed post. It is registered post or speed post?
Speed post.
Speed post. Pending consideration of the collector copy number so thus directed to take into consideration. Take a lawful order on the application herein, also keeping in view the grounds taken in the writ application as well as the documents appended herein. Let the petitioner serve a copy of his court's order and along with the copy of a brief. Okay, let the outcome be shown within a period of 2 months from the date of communication of order. Yes.
Item 5.
এটা বেশি রে করি না Mr. Panigrahi, basic CORAM. Yes,
Item 5, may I please?
Hmm.
In this case, my lord, 2 plots are in issue. The petitioner is in the possession of plot number 2197. But the opposite party number 2 has obtained the plot number in not final pota. It is ascertain that.
But how a read court interferes at this stage? There is mistake preparation of record of right.
Yeah.
Involving private party.
Huh?
Involving private party.
Private party involved because of
Okay,
wrongly
that's
mentioned your
another
name.
issue. But how High Court interferes in such matters? You
As
may
it
be
is
availing 34 or else section 15.
Is under publication. Is going to be publication Sampur area.
It is
going to be publication. Before publication, I am praying.
before publication, there is no provision in the statute. Not final RR to? Not
Yes,
final RR रे आपण ई दरखास्तटा देइचंती annexure 8 देइचंती.
Kindly say annexure 5, page number
Mr.
26.
Sahu, what is the provision of law now? Mr. Ghosh, you can also tell.
Yes. Set out the section 12A ରେ appeal କରିପାରିବେ.
ହେଇପାରିବ? 12A.
ଆଜ୍ଞା. OSS Act.
Let us permitting
No, my lord, it is
12A of the
kindly say annexure
OSS
5,
Act.
page number 26. Page number 26, kindly.
yes.
The opposite party number preferred an appeal case under 22B of OSS Act. In the appeal case, it is recorded that record HAL plot number directed to record 2196 of the Hal,
And there is a direction for correcting the record of, right?
no, my lord.
Yes, page 26, there is a direction.
Direction to get a 2196 plot number.
Yes.
But the settlement authority convert our
Oh, this is a proceeding under section
2197
22.
also kept in your.
Two re appeal nahi daw.
No, 22 2 that is treated as an appeal.
Already.
ASO order against SO
How appeal nahi.
Dita plot in issue. What
All
hochi
we are issuing notice.
96 21
We are
96
issuing
ଗୋଟେ
notice.
97
We are issuing notice.
notice କଲେ ଆଜ୍ଞା ହବନି
ଆଉ କଣ ଆଜି allow କରିଦେବି?
ନାଇଁ ତାକୁ direction may be granted to
କେମିତି
the
direction ହବ?
authority to
ଆପଣ judgment ଟା ଲେଖିକି ନେଇ ଆଇଲେ?
ଦିଟା
ଦେଲି ଆପଣଙ୍କୁ ଦାୟିତ୍ୱ ଆପଣ judgment ଟା ଲେଖିକି ନେଇ ଆସନ୍ତୁ ଯେ opposite party private party ଅଛି state ଅଛି ଆପଣ ଗୋଟେ order ବିରୁଦ୍ଧରେ ଆସିଛନ୍ତି ଏଇ stage ରେ କେମିତି ଲେଖା ହେଇକି ଦିଆହବ?
Item 6.
You have a case, notice has to go there to respond, then a judgment will come.
Status को मांगी करता है।
अरे दुकान ହେଇଛି ଦେଇଦବା ପଇସା ଦେଇଦିଅ ନେଇଯା କିଣିକି ଜିନିଷ
Status को मांगी करता है।
ଜିନିଷ ବିଷୟ ଅଛି କି ମିସକେସ୍ ଅଛି
Miscase भी fail करना है। Share that is what it is.
ନାହିଁ ଦେଖୁଥିଲି
For 6 second item also may be taken up first.
ଆଚ୍ଛା କି କଣ ଫାଇନାଲ ହିୟରିଂ
Finally, already my lords, it is covered by my lords decision.
कैलाश नायक case judgment जो आप putting D.
Ullas Naik, Ullas Naik.
Ullas Naik.
If my legislature says it is covered, then both have to be covered.
No, both have to be
Because
covered.
what is
ଦିଟା କଭର
ଯିବ।
କରୁଛନ୍ତି ପୁରା
ଆଜ୍ଞା ମୁଁ
it is
ଖାଲି
subject to outcome.
हाँ सेଠି civil court ରେ ଯାହା ହବ।
obviously, if mutation is allowed in my favor pursuant to the revisional order, it will be outcome of the civil suit. That is the decision of my
No,
lord.
no, my lord, it is, your lordship has not been pleased to my legislature is saying both ways. Your lordship's judgment, your lordship may kindly see 2022 2 OLR page 1133. Your lordship has been pleased to simply direct that this will be subject to outcome of the suit, my lord. My lord, what my legislature is saying that it should be mutated in his favor.
I mean the item number, second item, sub item, where my lord,
Yes.
the revisional authority
That is
allowed
also
the
subject
revision.
to.
I तो ଆପଣ ତ ନିଜେ 5ଟା order ନେଇଛନ୍ତି।
ସେକେଣ୍ଡ ଆଇଟମ ମାନେ କୋଉ କେସ୍ ଟା 10
10241 of 2021।
ଟିକେ ଅପେକ୍ଷା କରନ୍ତୁ ଏଟା ଫାଇନାଲ ଆଉଟକମ୍ ଅଛି ଫ୍ରେଶ ଆଡମିସନ ସରୁ ନବା it will be taken as last press admission no? Yes.
Item 7.
Demarcation application is pending annexer 4 OP2
list
demarcation application is OP2 my lord.
All right ଅଛି case number ଅଛି
No my lord. Till no.
pending ମାନେ
Application
କେମିତି establish କରୁଛନ୍ତି
annexer 4 application is merely.
annexer 4 cannot be treated as an application there is no deposit even sorry ଅଛି ସେଇ order ହେଇଛି the annexer 4 even though an application for demarcation undertaking demarcation exercise अच्छा ଆପଣ ପୁଣି removal of unauthorized obstruction ଆଣିଛନ୍ତି ତା ଦେହରେ ଇଏ ହେଇପାରିବନି ଆପଣ OPL ରେ proceeding initiate କରନ୍ତୁ
Only for demarcation my prayer for only limited prayer for
then make a fresh
fresh application.
Yes, sir. In the modification of the prayer herein and not pressing the repetition by the annexure 4, counsel for the petitioner seeks liberty of withdrawal of the application to apply the Tahsildar concerned for a demarcation exercise only. Okay, the repetition is permitted to be withdrawn, however, with liberty.
Yes. 8 be similar my lord. Annexer 3 is pending. 8 is similar 8. Annexer case number 8 serial number 8
Item 8.
Yes.
Annexure 3 is pending.
Again, 3 कौन पे खाली demarcation ये भी हबनी एमती डिपॉजिट କରିବାକୁ पड़िबो
similar
କରିବା ଅଥର କରିବି
କାଇଁ ଏମତି ଆପଣ ଆଡଭାଇସ୍ କରୁଛନ୍ତି କ୍ଲାଏଣ୍ଟ କୁ yes like annexure 3 though an application for demarcation is not supported with required fees and required format in the event petitioner brings a proper format application with appropriate fees same shall be considered and decided in accordance with law, however, providing opportunity to the parties likely to be affected.
Item 9.
May I please your lordship?
9 the other defects be permitted to be removed. Yes.
May I please your lordship? In this
Yes.
case, my lord, the petitioner praying for release of pending bill
an amount of rupees 16 lakhs 67,013.
What happened to annexure 2 series?
My lord, kindly have a glance annexure page 19. Your lord,
Page?
page 19 of my read petition.
Yes.
19.
They have already responded
Yes.
in the reduction in the amount.
No, my lord.
If
No,
case
my
is
lord.
not-
Your lord.
Pro-
Your lord,
Just a minute, just a minute, I will make it.
Annexure to
Just a minute. My
What-
lords, what happened?
say, call them.
my lord, your lordship kindly have a glance page 19, 20, 21, 22 of my read petition. In the page 19, BMC has already released that amount in favor of me. And that was held up by the then assistant electrical engineer, BMC. Now he deputed to BD.
उल्टा कुछ
Yes.
उल्टा कह
My lord, next, your lordship kindly have a glance annex page 20. That
Yes, page 19 is a payment order.
yes,
Instructed
in view of the instructed to
Chitranjan
the
Das,
instructed-
AE Electrical Bhubaneswar Development Authority is directed to take appropriate action.
Yes.
Okay, then page 20, what happened?
Page 20, in view of the above, last Sri Chitranjan Das, ex-AE Electrical BDA at present.
May be
be
instructed to transfer the final bill amount.
60.
Okay, then
Then, your lordship kindly, 21, page 21, that the reply given by the
Pune again there may be
city
again
manager
instructed.
BMC. that in-
Right, then what happened? Yes.
Chitranjan Das may kindly be instructed to settle the final bill amount in favor of Sri Ranjan Kumar
Okay, then
Sahu.
thereafter what happened?
Thereafter, nothing.
May I submit my lords one thing?
Yes.
Case is like this. The person, assistant executive engineer, who was working in BDA, was under deputation to BMC for some time to execute some work concerning after the devastating flooding. Then what that was the departmental execution of work by the municipality. Municipality credited some account in his account while he was under deputation. Now, after deputation period is over, he has come to BDA and joined there. The petitioner claims that he has executed the work. So, if the municipality has given the money,
Yes, you are agreed by annexure 4.
My lord. Annexure.
Annexure
Yes.
4, you have been directed to take shelter of law.
Yes, my lord.
You are agreed by that order. You
Yes,
are
my-
agreed by that order.
Yes, my lord.
Then what is the course left?
My lord,
There is a controversy.
my lord, that controversy, my lord and senior now.
Mr.
present
Mahapatra,
before
Mr.
this-
Mahapatra, if
that
you
reply
object,
has
then bring a counter affidavit.
I will bring a
Re-
counter affidavit.
Bring a
But-
counter
but
affidavit.
I will bring a counter affidavit, but fact remains, my lords, the total amount was given and accounted
Okay,
to
you
particular
first
officer.
bring the counter affidavit.
Yes,
On
my lords.
oral submission, nothing
But
can
my
be
humble
said.
contention is this.
There is already an order reasoning.
But the order
There is
is
some
there.
dispute. Therefore, the party has been directed to settle the
But
issue
in
to
between-
appropriate court.
In between them.
So now he says, no, it is a amount already in entitlement. Bring the counter, I'll take
I
it.
will bring the counter. I'll bring the counter. No
that
problem. I'll bring
reply
the counter.
has already been resolved.
Huh?
That reply has already been resolved in page 21.
All right. Let the Siddhanand Mahapatra and the counsel appearing for the contesting opposite party contest the claim of the petitioner. A counter is necessary. Let a counter affidavit be filed within 2 weeks. Matter will be
very
settled. Yes.
My lord, notice may be issued to the BMC, my lord. Next notice may be issued to the BMC.
Next item.
Item 10 may kindly be issued. BMC.
SCK bond for reading. Yes, item 10.
Notice issue alaba.
Item 10, you are also there.
No.
At the time of my hearing on mutation application by the annexure 4, the civil court judgment I could not produce by the time, page 36, though it is available under annexure 2, page 17.
What is your challenge here?
Challenge, my lord, without verifying the civil court judgment, page 36, the order 10/4/2023, the case record is put up today. Issue.
Mr. Mahanti, you are not coming straight with the issue. You are challenging mutation order or not?
Mutation order 5/7/2023.
So mutation order, whether it is entertainable in a
No, my lord. So I know because there is a provision of appeal, but the only thing is that latter part when I produce the civil court order, I filed a recall petition, page annexure 5, page 39. It was
that you did not produce in the process of the hearing.
Now
you have
small mistake.
Then what is the ground of rejection?
Rejection, my lord. The issue notice to the applicant for production of original court order for verification and general public.
Which order you are reading?
Upper order, 10/4/23 order ta. So page 36 ro.
10/4/23.
Again, the case record is put up today. Issue notice to the applicant for production of the original court order for verification and general public notice for objection.
Next order, what
Next,
happened?
the case record is put up today. The parties were present on the hearing date and on verification of document, but not the civil court order. It is seen that the case land belongs to a Chakka land as per provision section 34 of the OCS. It cannot be fragmented. So
what you say?
I am not any fragmentation. Say to order ta page 34 the ROR. Either mon nata entry hapo because by order of the civil court.
Was this part of a consideration? Was this part of a consideration?
Even the Chakka will remain in compact.
But you were never straight. Sorry. If it is a part of the consideration process, or you are bringing a new document here, so you can very well bring an appeal and additional evidence scope can be entertained.
So well, say, because recall petition of
withdrawn with in order to avail the appeal remedy. କହିଲେ କଣ ଭାବୁଛନ୍ତି ଖସିଯିବ ବୋଲି?
ନାଇଁ ସେଇଟା ମୁଁ ଦେଇଛି ମୁଁ recall petition ଦେଇଛି annexure 5.
ସେଇଟା appeal ବି ଦେଇପାରିଲେ ହବ.
Next.
Well, the appellate authority will take into account the civil court.
ଆପଣ ଆଗ ଆଣନ୍ତୁ ନା, ସେ ନ ନେଲେ ଆମେ ଦେଖିବୁନି ତାପରେ କିଛି କରିନାହାନ୍ତି ଆପଣ ସିଧା ଆସି ରିଟ୍ ପିଟିସନରେ ପଶିଗଲେ. Yes, next.
Item 11.
May I please your lordship? It's a OLR 22 matter. My lord has already passed similar order. It's a cover matter.
Yeah.
Item 12.
May I please, my lord? Petitioner in this case, my lord, is the proprietor of Messrs. Ansika Industries at Rajendra Nagar, Madhuparna, Cuttack, my lord. In the year 2018, my lord, he has applied for a plot of land measuring an area acre soon 60 decimals from of Idco land at industrial estate, Cuttack, my lord. His application was duly considered. He has deposited the amount, my lord, under annexure 4 and 5, but his case has not yet been considered, though others are getting their lands, my lord. Annexure 6, your lordship, kindly see.
What is the foundation in your claim? Where is the allotment order?
My lord,
where is the
they have not allotted the, my lord. They have taken the money, they have not yet allotted the land, my lord. Annexure 4, your lordship, kindly see. I have deposited the money, entire amount, my lord.
Is it a deposit person to demand under annexure 3?
My lord, my annexure 3, my lord.
History କହୁନାହାନ୍ତି କାହିଁକି ସିଧା jump କରି ଯାଉଛନ୍ତି ଆଜ୍ଞା ଟଙ୍କା ନେଲେ ଦଉନାହାନ୍ତି. So therefore there is a it is କଣ ହେଲା inviting reference subject cited above. I am directed to intimate you your proposal for allotment it go plot so and so has been approved. ସେଟା ପଢୁନାହାନ୍ତି କାହିଁକି? ସେଟା ପଢିଲା ପରେ you may be justified saying again here I have been asked to deposit certain amount which I have deposited under annexure 4.
My lord.
And thereafter even they are not executing the document. That's all. Okay, all right, take notice then. Issue notice on the question of admission fixing short returnable date. Requisites as undertaken be filed by day after tomorrow. Matter will be listed immediately after appearance of the opposite parties. Yes.
Item 13.
Item, sorry, Lord. I'm sorry to interrupt, Lord. The item 11, like this something, Lord. In fact, Mr. Guru said this covered, Lord. In the earlier occasion, this has come. Your Lordship has granted us time to file counter affidavit in view of the appeal filed. Already ordered to hear counter affidavit like that. କାଲି କେସ
ତାଙ୍କୁ ଖବର ଦେବେ
ହଁ ତାଙ୍କୁ
ଖବର ଦେବେ। Yes. OLR case is pending since 2018.
Tahsildar Padamba.
Okay, considering
Writing case
Inako's
number
request, but I
one
am
by
expressing its anxiety in long pendency of OLR case 1 of 18. Sub-collector Radgord is directed to see lawful disposal of the same, while also providing opportunity to the private opposite parties hearing by concluding such proceeding at least within a period of 4 months. Yes.
May I appeal, Your Lordship? Your Lordship, please to allow one writ application in favor of mine. Thereafter, Tahsildar issue notice to appear before the Tahsildar. I appeared there, but the Tahsildar has not given giving me opportunity to hear my statements. That is why I filed this writ application.
What is the issue?
Issue regarding some portion of land has been occupied by some Jamin Apya Jagawant Padi Matar
Then you are requesting exercise of the authority under what provision of law?
My Lordship, kindly have to annex 2, my Lord. Regarding conduct on the basis of said letter, my Lord has pleased to allow this application.
No, I don't go by all these things. You want exercise of the action of the authority under what provision of law?
Regarding under OGLS Act,
OGLS, then it will go to OGLS court.
Well, because
it will, no, you can't just seek a repentation disposal here. There has been certain developments.
Annex 3 has been issued by the Tahsildar.
On the own submission of the petitioner appears to be undertaken under the provisions of OGLS Act. Annex 3 also is a demonstration of exercise of such provisions. In the circumstance, this court has no such assignment. Rest is directed to bring it before appropriate assignment.
Item 15.
My repeated prayer in this petition. Our grievance is pending before opposite party number 3 under Annex 9 at page 164.
At page Annex
164, Annex 9.
So that needs to be considered only.
Yes.
Prayer quote karne. The Pradhan Learned Counsel appearing for the petitioners at the same time brings to the notice of the court through Annex 9 on pendency of the representation of the petitioners on the self-same issue. You are sure petitioner is a signatory in the here?
Yes, my lord. Yes.
Just come to serial number 22. Next page, 166. 166.
My lord.
Serial number 22.
My lord.
Serial number 22. देखिले की
22 petitioner number.
Serial number ma page 166 रे.
My lord.
Is also interested. No, considering the pendency of the representation at the instance of the petitioners, pending consideration of OP number
3, my lord.
3. Expressing its anxiety that such representation, the representation submitted on 27/3/23 should not have been kept pending for over 5 months, nearly 5 months. This court direct the OP number 3 to take a lawful decision on the same in the involvement of petitioner and also in the involvement of any party likely to be affected by the outcome of such proceeding. Outcome be shown, lawful outcome be shown, also keeping in view the grounds taken in the writ application as well as material support taken therein, at least within a period of 2 months from the date of communication of order, along with the copy of the brief. कौन कहीं होने मु 4 वर्ष तळु कहलिनी जे जदि रिप्रेजेंटेशन टे काहर आसुची that should be disposed of at the earliest. Why should a person come to High Court to take a mandamus of this nature? Improve होउनी आपण माने भी देखु नांदी सुनतो discharging certain duties within time frame therein. हमको एप्लीकेशन एतिक दिन रे सारिवे हमको रिप्रेजेंटेशन एतिक दिन रे सारिवे दैट इज ऑलरेडी लॉ प्रेस्क्राइब गोटे दिन डेरी हेले 250 टका फाइन हबो सेटा जेंति अछि इट इज लाइक दैट ऑफ इंफॉर्मेशन एक्ट सेटा के इंश्योर करूना सेटा जदि दि चारटा पब्लिक अफसर ऊपर फाइन ही जानता ये सजाड़ी जानते
Item 16.
Yes. This is in a show moto rent fixation proceeding.
Pardon?
In a show moto rent fixation proceeding, the order was against the petitioners. They filed an appeal before the London ADM, and during pendency of the appeal, an application under Order 1, Rule 10, CPC was filed for impletion of some persons as parties. It was allowed. In spite of objection, stating inter alia that this court and as well as the civil court has denied their.
It's just addition of party.
I know.
So how are you affected?
They are not necessary and proper parties, my lord. I have already given the. And this court, your lordship may kindly turn to page 35.
Okay, already yes, Mr. SAHOO, have you seen that order?
Yes, sir.
How can you allow Order 1, Rule 10 without assigning any reason? So let it go. Private party thive puni. Gala notice gala. The case is
Page 35, your lordship may kindly.
involving an unreasoned order in allowing Order 1, Rule 10 to application. In the order dated 5/7/23, Vide Annexure 3. Okay, this court, though satisfied that the impugned order doesn't bear any reason, in spite of serious objection of the petitioners herein. However, proceeding cannot be concluded. This proceeding cannot be concluded in absence of the contesting opposite parties herein. This court accordingly direct issuing notice. Stay of further proceeding kar daba.
Stay of
further proceeding.
Stay of impugned order, man.
Impugned order हेले proceeding जदि continue कर जिवो suppose final outcome आसीबो आपण एठी lose करिवे कोन हबो? Don't pray in such manner. Be reasonable.
Yes.
अरे हमें entertain करू अर्थ नुहे जे हमें छाड़ दवा पार्टी को लॉर्ज रे छाड़ दवा. Let there be stay of further proceeding in so and so Annexure 3 time.
And there is a finding of this court also.
Oh ना मु जानि छै कि आपण very intelligent. मु ता कहबी खाली से ऑर्डर टा स्टे कर देले से प्रोसीड कर जीवो तापर से फाइनल आउटकम देई देबो
this court
ताले
has
कोन हो
given
से ऑर्डर टा काई आ रहिबो
नहीं this
so
court
wait,
has already given
wait
a
let them come requisition has undertaken by tomorrow matter will be listed immediately after for short question involved within matter may be listed immediately after appearance of private opposite parties.
Item 17.
This court even can consider suppose reason नहीं this court can consider the nature of application and the objection may give its ruling.
This application was once considered by this court, and I have given the order. In a CMP, this court has denied their impletion.
Principle is applicable, not applicable. देखिवा आसन सेमन आसिला पर देखिवा.
Item 17.
May I please your lordship?
Yes.
The petitioner is a landless person, my lord. He made a grievance to the Tahsildar for settlement of land under Vasundhara scheme.
Vasundhara scheme?
My lord, under Annexure 2, my lord.
That is pending?
That is pending before OP number 6.
What Annexure 1 series?
Agya, collector Tahsildar.
Tahsildar direction of Annexure 1. Self-same. All right. By taking appropriate exercise within a period of 3 months and entering into inquiry to find if the petitioner in fact is a landless person or not. Landless person in the state or not. Yes.
Item 18.
Millard. Millard, all four writ petitions are covered petitions.
Covered.
Huh.
Have you
Millard,
applied?
I have enclosed the orders of
Order
this honorable
64.
court. Huh.
Page 64.
Huh.
All right.
All four writ petitions.
Item 19.
Please, your lords. In this case, my limited prayer for early disposal of the RP case number.
Pleading completed in that proceeding.
Total notice in, my lord.
So fresh admission kariba and
Total
also-
notice in.
Okay, fresh admission hoba and disposal also within a period of 9 months.
Highly blessed.
Item 30. Sorry,
20.
item 20.
20, my lord. Direction for disposal of CRP number. 60.
Disposal?
Yes, my lord.
Pleading
No,
completed?
not completed, my lord. Not admitted, my lord.
And not admitted, ତାହେଲେ ମୁଁ dispose କରିଦଉଛି ଆପଣଙ୍କ prayer allow କରିଦଉଛି by rejecting that application.
No, my lord, your lordship.
ଆପଣ ଆଗରୁ
Direct-
କହିବେ ନା ଆଜ୍ଞା fresh admission ପାଇଁ ଯାଉ ବୋଲି
ଆଜ୍ଞା।
ଆପଣ disposal it ଚାହୁଁଛନ୍ତି ଆମେ dispose କରିଦବା
No.
fresh admission
All the matters are set.
prayer ରେ ସେ ଲେଖି ଦେଇଛନ୍ତି ବୋଧେ
ଆଜ୍ଞା, ନାଇଁ ନାଇଁ ସେ ଲେଖା ହେଇଛି for admission and disposal.
କେମିତି ହବ dispose notice ହେଇନି objection ଆସିନି pleading complete ହେଇନି
ଆଜ୍ଞା।
dispose କେମିତି ହବ by way of dismissal only ନା ନାଇଁ
ଆଜ୍ଞା।
Item
Yes.
21.
Yes, next.
May I please, your lordship? Your lordship, after receiving further instruction, I need to file an amendment to the prayer of this petition, my lords.
You want to file?
My lords.
Okay,
My lords, may
petitioner
grant me some
seeks-
time, my lords.
Petitioner seeks time to bring amendment application involving the prayer in the writ application. Okay, how much time you want?
My lords, 7 days or 10 days, my lords.
Okay, 7 days time granted for bringing such application. That will be placed immediately after filing of such application.
I am grateful, my lords.
Next.
Item 22.
22, my lord, your lordship order, my lord. 28, my lord, page 28 is similar to lordship order, my lord. Page 20 for settlement of land, my lord.
And so 4 is pending.
4 is pending. Annexure
Okay,
5,
annexure
page 28,
page
your lordship order, my
Page
lord.
28 is the order. Okay, all right. ସେ ବି covered order ରେ ଦେଖା ହଉଛି. Right.
Item 23.
Annexure 7 for finalization of the done declaration proceeding under section 12 and 13.
Pardon, please repeat.
Annexure 7, page 30, my address to the Tahsildar for finalization of the declaration proceeding under section 12 and 13 of the Bhutan Act. Annexure 6, the guidelines framed by the Board of Revenue to all collectors.
6 is pending.
7 is pending.
The
We
7
decide-
is to be considered in terms of 5 and 6.
Say 5 and 6.
No. Prayer court karibo 7 to be considered. By OP number?
By OP number, my lord, 3.
3.
Tahsildar, 3.
Okay, taking into account the development through annexure 5 and 6. All right.
Item 24.
This is my lords have passed the identical orders, page 43.
Yes.
By virtue of Narottam Rath case. Page 43, my lord's order, and 45 is the batch of cases. Like is similar to item number 18.
Private party ଅଛନ୍ତି କି?
ନାଇଁ ନାଇଁ ସେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଯୋଉ ସେଟଲମେଣ୍ଟ ଯୋଉ WS ଏଟା କ୍ୟାନ୍ସଲ ହେଇନି ତାକୁ ସବୁ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ନାଁରେ ନେଇ ପଡିଛନ୍ତି।
So only government is only opposing party.
ଆଜ୍ଞା।
All right, take out notice.
Similar order dispose item 18. Item 18 the similar case dispose of.
Item 18 ରେ
ଆଜ୍ଞା।
ଯାହା order ହେଲା।
ଆଜ୍ଞା। ସେ ଏଇ କେସରେ ସବୁ କରୁଛୁ।
ହଉ, all right.
ଖାଲି annexure 6 ହବ 1 ଜାଗାରେ। 1 ଜାଗାରେ annexure 6 ହବ।
Annexure 6 ହବ, 18 ରେ 1 ହେଇଛି।
Item 25.
May I please, my lordship?
Yes.
On behalf of SK Naik.
Yes, what are you challenging?
Challenging the order
challenging the order passed by Deputy Commissioner of Cuttack.
Okay, right, there is some proceeding initiated, this order automatically comes. There is some proceeding on unauthorized construction.
There is no unauthorized construction.
You
Only
say
the-
there is no, then you appear there and bring your objection. There is complaint
Sir,
against you pending.
Sir, like there is similar matter where there is learned justice A.K. Mahapatra order the same. There is no unauthorized construction. Then in this matter also.
At this stage of the matter,
uh,
it is only while issuing notice in UC case, there is a restraining order. So how can we consider at this stage?
my
Sorry,
limited
that may be
kindly-
final adjudication of the proceeding.
Kindly
Here-
admit the matter and issue notice to opposite party.
I don't find any reason in issuing notice in such matters. When do the authority will come to conclude that there is no unauthorized construction?
Copy also served to the opposite.
No, when do the authority will come to conclude that there is no unauthorized construction?
No, sir.
When?
They just
Oh, you are not answering.
they pass.
ଆଜ୍ଞା ଆପଣଙ୍କୁ ଗୋଟେ unauthorized construction ର notice ଆସିଛି କି ନାହିଁ?
Yes, yes.
ଆସିଛି। ସେଇ notice ସାଙ୍ଗରେ ଗୋଟେ notice ଆସିଲା ଯେ ଆପଣ ଆଉ further construction କରନ୍ତୁନି।
Yes, yes, ma'am.
ଆସିଲା।
ଆସିଲା।
ଆପଣ ସେଠି ହାଜର ହେଲେଣି କି?
ମୁଁ ହାଜର ହେଲି।
ଆପଣ ସେଠି ଯଦି ହାଜର ହେଇନାହାନ୍ତି ହାଇକୋର୍ଟରେ କେମିତି କହିବେ ମୋର unauthorized construction ନାହିଁ?
Because ମୋ ଚାରିପଟ ଜାଗାରେ ଯୋଉମାନେ ଅଛନ୍ତି ସେମାନେ
ଆପଣ ହାଇକୋର୍ଟକୁ କହିବେ ନା ସେ ଅଥରିଟିକୁ କହିବେ। An order of no construction in the pendency of UC case 9/23. Okay. Undisputedly, there has been initiation of an unauthorized construction case 9 of registered as unauthorized construction case 9 of 20, appearing to be under the provisions of section 92(1), 92(2) with a Roman 1(2), of the OD Act. Looking to the, you have filed your objection there or not?
No, my lordship.
File karnahanti. Okay. Looking to the stage of the matter, this court find the repetition becomes premature. In entertaining such issues at this stage, in the process disposing the writ application, this court permit the observe. In the event the petitioner is yet to bring his objection to the unauthorized construction case involved herein, shall bring the objection before the competent authority at least within a period of 7 days hence.
Annexer.
In such event, the competent authority shall consider the
Pardon, my lordship. We have filed the objection.
filed objection.
Yes, my lordship. Annexer 4.
Okay, okay. Considering petitioner has already brought his objection, its objection, her objection. By annexer 5.
Annexer 4. Sir.
4 and 5.
4 and 5.
Voilà. This court direct the competent authority to consider to undertake the adjudication exercise involving such proceeding in the involvement of the complainant as well as the petitioner and take a lawful decision by completing such proceeding at least within a period of 2 months from the date of communication of the order. Yes.
Item 26.
I am permitted to withdraw with an liberty to file in appropriate forum.
Petitioner seeks withdrawal of the writ application with liberty to bring application before appropriate forum.
And delay
Permitted to be- However, with liberty.
liberty delay delay
Delay condone upon city file the application.
Sir,
You can't route appeal by this way. File କରନ୍ତୁ ଆପଣ ସେଠି delay condonation ମାଗନ୍ତୁ ନଦେଲେ ଆମେ ଦେଖିବା।
ଆପଣ ଗଲାବେଳେ ଟିକେ
No, ଆମେ ଏଠି କହିବୁ। ଏଟା କଣ state କେବଳ opposite party?
state
State କେବଳ opposite party। କେବେର order ଅଛି?
91
ଆଁ?
91
91। ହଁ ବଢିଆ ଆଉ ବୁଝିଲେ
Land
ସରି
land ଆମର settle ହେଇଥିଲା
ସରି ଆଉ ପଦେ କହିବେ ମୁଁ ଏଇଠି ରିଜେକ୍ଟ କରିଦେବି ଦେବିନି ଆପଣଙ୍କୁ ଲିବର୍ଟି ବି ଦେବିନି
Item 28.
my lord 27
27 ଡାକିବନି
Item 27.
my lord this matter is covered by your lordship's order under annexure 2
କେତେ ପେଜ କେତେ
page my lord 9 ରୁ 11
9 ରୁ 11 ହେଲା ଦେଖିବ yes
Item 28.
That's page, order is at page 12. That order is at page 12, what my learned senior is referring to.
ଦିଟା ବ୍ରିଫ ଅଛି ଦେଖିଦିଅ ହାଇକୋର୍ଟ ଅର୍ଡର ହି ହାଜ ଆପେଣ୍ଡେଡ
Yes, annexed, that's page 12, your lordship.
ଆପଣ କେସରେ 12 ରେ ଅଛି
My lords.
ଆମର 9 ରୁ ଲାଗିଛି 11 ରେ ଅଛି all right we'll see to it yes
Item 28.
May I please your lordship? Here, your lordship, after obtaining the decree in civil court,
ମାଇକ କୁ ଟିକେ ତଳୁ କର
after obtaining a decree of civil court, I have filed a mutation, your lordship. Thereafter, my mutation dropped, that is page 28, your lordship, mention the ground.
read order dated 25/5/22
The case is put up today, peruse the document filed by the applicant. It is revealed from the document filed by the petitioner that he has not submitted the genuine document correction of RR in favor of the petitioner. Hence, the case is dropped, your lord.
so what is your submission
I pray, your lordship, I will file fresh mutation, your lordship, by submitting correct document. your
for
lordship.
that a writ liberty is necessary this is dismissed on technical ground
My lord,
so why have you approached under a writ jurisdiction
because same
okay undisputedly impugned order herein appears to be a technical rejection for petitioner not bringing in the genuine documents to support his claim. For the opinion of this court, for this purpose, no writ permission is necessary. Writ court permission is necessary except as it is always open for the petitioner to bring a fresh mutation case, but however, in the support, in the enclosure of in the appendix of the genuine document, if any, to support such claim.
Okay.
Item 29.
This observation, the writ petition stand disposed.
May I please your lordship? My lord, demarcation application is pending before OP number 3.
Application is annexure 2, all right.
Annexure 2, page 9.
Through annexure 2, petitioner establishes to have already made an application for demarcation, all right. In the event any such application pending, directed to be disposed of within 3 months, providing opportunity to parties likely to be affected. Tahsildar Bahanga.
Tahsildar Barango. Tahsildar Barango.
Barango. OP number?
OP number 3.
Yeah.
Item 30.
The peculiar order has been passed, and the commissioner under section 15B has set aside the consultation order. Page 36, may kindly. Consultation order passed in 1993 is page 36, my lord.
Yes.
That one, second para. That one, perusal of the document filed by the petitioner, the flow of title of the recorded owner to present petitioner is seen established from verification objection case number so. It is found that some discrepancy there in regarding order passed in the assistant consultation officer in objection case number so and hereby set aside in both the documents submitted you. And your lordship may kindly see the very same person who now is the power of attorney holder is the principal. He had filed that objection petition, and objection petition has been allowed way back in 1993. My lord, may kindly see page annexure 3, page 18. But how he can, the settlement commissioner can set aside consultation authority's order that is recorded since 1993.
All right, then private party involved?
A private party, naturally.
So take notice.
My lord.
Issue notice on the question of admission fixing short written out date. Considering this accessory proceeding, registry directed to place the matter immediately after appearance of parties. Requisites as undertaken by day after tomorrow. In this case, notice as above, status quo in respect of the disputed property as on date shall be maintained In the pending.
Para 3, I have given the details. In para 3 of the IA, I have given the details.
Schedule of property.
Schedule of property. Para 3.
In respect of
IA.
para 3 mistakes.
Well, I also say that third party interest also may not be clear.
Status quo heଲେ ହବନି
Status quo heଲେ ବି ସେ ଆଜ୍ଞା ହୋଇଯାଉଛି ସେମାନେ କରିଦଉଛନ୍ତି ବହୁତ ତିନି ତିନିଟା case
maintaining status quo in respect of the disputed property, there shall be also no attempt for creation of third party interest involving such property in the pendency of the writ application. Mr. Mishra, senior counsel. Yes. Right.
Item 31.
31, we have filed the KVA on behalf of PPL. Like, understand, get a copy of the writ petition.
Limited prayer before your lordship. This, my learned senior.
Pardon?
Limited prayer before your lordship.
Limited prayer. Copy to देई दो ना दी.
In course of the.
Also, any day.
Copy दियो तो काली करिवा.
Kali karo.
Tomorrow कर दो. Let him get a chance. He has been already instructed. Why are you depriving him from getting
My lord,
this?
my lord.
Brief copy of brief is served on the associate of Sri Nanda Learned Senior Counsel.
Your lordship,
Who have already the instruction to, no, or you have appealed through caveat.
No, we have appeared filed KVA, but my learned associate's name may be mentioned on.
Upon na lekha hoboni.
No, appearance may, because he cannot serve copy on me as a.
Khali tanko na lekhiwa aji.
As your lordship wishes, I have no problem, but appearance your lordships can note, but to serve a copy has to be on.
Yes, definitely. I have given a direction for serving on the associate.
Associate, yes.
आपको तो दे ही परिवेनी.
आगे.
आपको दे ही परिवेनी. वो लंबा.
LED disposal.
Revision is pending since 2005.
2005.
Is what these officers are doing.
Lodge.
2005 revision. It is 18 years over.
Madam, 2007. 2005, I am filing the RDC in 2 of 2005. RDC remand the case OP number 1 in 2007.
Remand alla. Ta pare bhi he paruni.
Na.
Okay, it is unfortunate to note. Repetition involved following prayer. It is unfortunate to note that the RP2 of 2005, even after remand order dated 30th 3/2007, remain undisposed. Almost 16 years have passed in the meantime. There is unnecessary loss of time in such proceedings, causing serious impediment in the parties before in the litigation. With the above observation, this court in disposal of writ petition direct the Revenue Divisional Commissioner OP number. Which OP?
But the Tahsildar will.
Okay, now the remand Tahsildar.
Lordship.
Okay, Tahsildar Rairangpur, opposite party number so and so is directed to conclude the proceeding at least within a period of 3 months from the date of communication of order. Page 11, he was directed to conclude within 3 months, and
Lordship.
in the meantime, 16 years have gone, and it must have seen 10 Tahsildars.
Item 33.
33, my lord, may I praise arise out of a regulation 2 matter. The eviction order has been confirmed in appeal. My lord, here, my lord, my father was the appellant. He died on 3rd of November 2021. But the impugned order has passed in 2023. I didn't know about this proceeding altogether.
You are the legal heir.
Yes, my lord.
But the proceeding is.
I am the Rajat, my lord. I am Rajat. My father was Vidyadhara is the appellant before the
decided involving a dead person.
Yes, my lord.
Okay, all right, take notice that. It's a notice of the fixing short returnable date. Considering private opposite parties there, requisites be filed in so and so manner. All right. What is the interim application?
My lord, there is an eviction notice being issued against me.
Stay of impugned order.
Obliged.
Requisites by day after tomorrow. ଆପଣ ରେଗୁଲେସନ 2 ରେ କୁଆଡେ ଆସିଲେ?
Item 34.
Page 30, the demarcation notice I have challenged. Matter traversed before the civil court
came to this honorable court in their second appeal. Second appeal was
Same
disposed of.
property.
Yes,
Same property
ma'am.
is already involved in a civil proceeding.
Civil suit and second appeal is also disposed
Then
of.
you-
My apprehension is that my homestead is there, they are demarcating now.
Mr. Misra, then you bring that objection before the authority. He
You
will
will also
first
may look at the
decide-
notice.
He
He
will
issued-
first decide whether such a petition is entertainable or not.
My lord,
That's all.
he issued me notice on 17/8. Fix the date to 23 without giving me any scope.
ଆଜି 23 କଣ ହେଲା ଆପଣ ଯାଇଛନ୍ତି ସିଆଡେ ନା ନାଇଁ?
ଆଜି ଆଉ ମୁଁ instruction ନେଇନି ଫାଇଲ କରିଲି କାଲି ଆଉ
କଣ କରିବି ମୁଁ? ଆପଣ କ୍ଲାଏଣ୍ଟ କୁ କଣ ଆଡଭାଇସ କଲେ?
objection ମୁଁ ବି ସେଇଆ କହିଲି।
In this situation ଆପଣ କ୍ଲାଏଣ୍ଟ କୁ କହିଲେନି I am
ସାର୍
putting a writ
ପ୍ରକୃତରେ
application.
ସୁଟ୍ ରେ ରିକଭରି ଅଫ ପଜେସନ ମଗାଇନି। ସେକେଣ୍ଡ ଅପିଲ ରେ ଚାଲିଥିଲା ସେ ଅଲଗା କଥା। ମତେ
Question
ମୋର
ହଉଛି କଣ
apprehension
କି?
ମତେ
ଆମେ ତାହେଲେ
dispose
କାଲି
କରିଦେଲେ।
ଏଇଟା ନବା ଆପଣ ଆସନ୍ତୁ ବୁଝିକିରି ଯେ କଣ ହେଇଛି।
ଆଜ୍ଞା
ଆଜି କାଳେ ସେ ସାରିଦେଲା।
ଆପଣ ଲେଖିଲେ if not ଆଜି ମାପ ହେଇନି 17 ତାରିଖରେ ନୋଟିସ କଲେ 23 କୁ ଫିକ୍ସ କଲେ
Submission of
Straight away-
Misra as well as Biswanath Misra for respective councils. Writ petition simply involve a notice of the opposite party number. Tahsil there Marsag OP number so and so involving undertaking a demarcation exercise by demarcation case 60 of 2023. Annexure 3 has a clear disclosure of posting of the proceeding to today itself. The Misra and Council submits the party herein has already brought an objection. Taking this court to the history involving the disputed land, Shri Misra raised this objection in the entertainability of the demarcation proceeding. For the opinion of this court, in the event self-same property is already involved in civil dispute and also in the involvement of the parties herein, no further demarcation proceeding be entertainable. However, for the petitioners, since already brought an objection in the above light, for consideration of the Tahsildar Marsaghai involving demarcation case 60 of 23, considering the case is already posted to today, this court observed in the event the proceeding still survives, the objection of the petitioner on the entertainability of the proceeding, if any, shall be considered as first step of the matter. If the proceeding survives, it may be open to the competent authority to proceed further. If proceeding doesn't survive, that ends up the matter.
Till consideration, no demarcation. Till consideration of my objection, no demarcation. Sir.
Okay, till. नहीं सेटा हेले तो आगो मु कहली कि से डिसाइड करिवे एंटरटेनेबिलिटी आ डिमार्केशन हबो केमति ए जजमेंट देखिले मिस्टर मिश्रा फाइनली हां जजमेंट ऑलरेडी रिपोर्टिंग हे गलानी
May I place your lordship?
देखिबे
I am grateful your lordship.
देखिबे that is the first judgment of its kind. So hereafter any court undertakes such exercise only the computation aspect on the permanent alimony straightway follow that formula and proceed.
Different procedure were being adopted.
Now there is a concrete procedure.
I am obliged.
Yes, next.
Lordship, this is a contempt petition.
First
where the
contempt.
Yeah.
First contempt.
Yes, Lordship.
All right.
That's a copy may be served on us.
They don't copy.
Item 36.
Copy will be served as a friendly service, not by way of notice.
My lords.
So therefore, no court order will be there.
Lordship.
Served.
Lord, this is a contempt.
First
Actually,
contempt.
Actually, it is a fourth contempt, my lord.
Fourth contempt.
Yes, my lord. Because initially the writ was filed. Lordship, the Tahsildar violates the order of this honorable court. There are again contempt was filed. And also, Lordship directed.
All right. Your certificate discloses so many contempt petitions also. And another writ petition also subsequently.
subsequently.
Okay, take notice, take.
My humble petition, small humble
Take
petition
notice.
is that.
Take notice.
Yes, my lord. One point, my lord, I am submitting. After filing of the contempt, the Tahsildar issued a ROR. This is an incorrect ROR mentioning all jungle.
That cannot be taken care of in a contempt proceeding. That cannot be taken care of.
My lord.
What was the redirection then?
Issue corrected ROR.
Yes, another.
Oh, now that it is
Here
already
issue.
issued, no contempt will lie.
Lords. Yes, my lord, I will file a writ petition.
Okay.
Another writ petition.
So this contempt will no more be entertainable. On the own submission of, you are Mr. Sanjeev Roy?
My lord.
On the own submission of Mr. Sanjeev Roy, there has been bringing out of a fresh corrected record of right, but again, a mistaken record of right. For there is already bringing out a corrected record of right. Issue whether the record of right is correct or incorrect cannot be decided in a contempt proceeding. Petitioner is to find out other options available. Well, the content application presently no further entertainable. Bring a writ petition immediately.
Item 6, pass over item 6.
My lord, in item 6, your lordship, so far as the second item is
Let us
concerned.
go by one by one. Mr. Mishra, yours is the second case. So let us first decide the first case.
Second case, my lord, second case should be taken up first.
First case result, first case is dependent on an outcome of the second
yes,
case.
yes.
Okay, then let us take the second case first. What is the number of second case?
My lord, WPC 10241 of 2023, my lord.
10241. Yes.
Of 2021, your lordship.
There, my lords.
Definitely.
Here I have challenged.
Here you are the petitioner.
Yes, madam.
All right, argue.
Here the challenge is to the revisional order, my lord, wherein a revision application has been entertained after 68 years.
Revisional order annexure?
Annexure 8, page 40.
Annexure 8, 40. And this is under the Settlement Act, which your lordship have been pleased to hold that it is subject to outcome of the suit.
Just run away, yes. Your challenge is to the order of the RP case 1808. This appears at annexure 8.
Your lordship.
Okay, come to annexure 8, page 40.
40.
Yes, yes. What is your ground of challenge?
Ground of challenge, my lord, the application was filed 68 years after the, my lord, sell deed, alleged sell deed.
Okay.
And further, my lord, they are, as per their own admission, they are not in possession of the full land, though I have said that we are in possession, but they say they moved out from that place after the, my lord, the death of the original, my lord, Vendi. They are the legal heirs. They said they move out of the place, and their own admission is also that.
Mr. Mishra, don't run fast. Go slow. These are revenue matters. So where is your objection to such proceeding?
But there I have stated, your lordship will see, I have not been provided opportunity that I have stated, your lordship will kindly come to page.
So your second ground, you have not been noticed even.
No, my lord, my ground is that this delay aspect, my lord, I have not been given opportunity to object. A report was called for. Report also, my lord, has been, my lord, I have not been given.
Decision on delay, is it independent decision? Or it's a decision along with the merit?
Along with the merit.
Along with the merit, then there must involve an objection of yours. You have been noticed in the proceeding or not?
I have been noticed.
Para 2, now notice was issued to the opposite parties. Opposite party.
Mr. Mahapatra, please take your seat. Please take your seat. Yes, Mr. Mishra, were you noticed in the RP or not?
I was noticed, Your Lordship.
You were noticed. So if you find it is grossly delayed, have you brought such objection or not?
But we have questioned that, Your Lordship.
Pardon?
We have questioned that.
You have questioned that. Where is that question?
My Lord, Your Lordship will
By
kindly.
way of response or in the submission?
Because he did not, my Lord, he did not consider that separately. He
No,
considered in the
first of all,
repetition
let
itself.
us see the foundation. You have raised or not? This
My
is
dear
a
Lord.
secondary proceeding. If you have raised, then bring to my notice that yes, I have raised and this is
May I
the
just
recording.
point out one thing? Why separate objection could not be filed? That is because page 7 of the writ application, paragraph 7, Your Lordship may kindly produce. There has been no separate notice with regard to condonation. He has considered along with the merit.
Right, let us assume there is straightway hearing. There is
My Lord,
straightway
I have
hearing.
not been provided
Have you
any
raised-
opportunity
have
for.
you- Mr. Mishra, have you raised this question or not?
My
Where,
dear Lordship will
where has he
I-
recorded that you have raised this question?
My Lord, I have said that I have not been
So
provided
your
with.
thing is not sufficient.
I have stated in
Unless
my
you bring that question to the authority, you can't blame the authority that he has not considered such question. You are developing case here.
I am not developing here. He has decided the case together.
Bring that line where he has recorded you have raised this question.
My dear Lordship, may kindly see.
Kindly see means I will go through the entire order.
No, my Lord, the discussion that has been made with regard to sufficient cause, that is at page
There is no such
page
recording.
44. Page 44.
44.
And
Yes.
it commences from, my Lord, page 43, and the discussion is at page 44.
Yes.
While opposing the revision prayer, page 43.
43.
While opposing, my Lord,
Yes, while opposing revision.
prayer, the learned counsel for the opposite party cites decision of the Honorable High Court passed in writ appeal number so-and-so published in 2017 to ILR Kotak 1240, wherein the Honorable High Court has held that in this case proceeding under section 15B of the Act initiated, having not approached the revisional authority within a reasonable time, are to suffer for their own negligence and laches. Learned counsel for the opposite parties has further argued that Section 1, Rule 10 of the IE Act, the burden lies on the petitioner to prove that they are in possession of the case land in question. He also stated that the Tahsildar is not competent to declare the right title interest over the case land if it is disputed. In its counter submission to the opposite parties on the point of the learned senior counsel for the petitioner has relied upon the citation of the Appeals Court on 1998 7 SCC held that rule of limitation are not meant to destroy the substantive right of the parties. Then he has dealt with that sufficient cause in the next subpara, page 44, so the second subpara, Your Lordship.
Yes, Mr. Mahapatra, just 1 minute. Mr. Mahapatra, such a question is raised.
Yes, ma'am.
Then this is covered by my judgment.
Which one, madam?
Covered by my judgment. Such a proceeding, delayed proceeding cannot be entertained.
On delayed proceeding cannot be entertained, but here in this case, the learned court below, because commissioner considered these aspects and passed that order. And my humble contention is that it is also covered by this one because this has been already, there is a direction for recording of record of right. If my learned friend, the client of my learned friend is aggrieved, then before a suit panels can challenging this. That right is there with him.
No, that right is there. Why right of a party will be disturbed after 68 years?
No, my question is that after 68 years, substantial justice means something else. Minors wanted to hear that matter so far the limitation part, why that have the learned court have considered, because there are some mischiefs and there are some fraud, and that is what also minors may take up at any other day. I will bring it written in out of that so that minors can approach.
Where is your revision petition?
My revision petition, minors. And that is at page 15.
Page 15, Your
15.
15.
Yes, please take me to that portion on the limitation aspect.
Limitation, my lords.
Annexure 3, your lordship.
Annexure.
No, the petition is annexure 1.
Limitation annexure 3.
One.
IA for limitation annexure 3.
Annexure 3, my lords.
There is a petition for limitation.
Limitation and objection to that.
Yes, come to that petition. Even annexure 3 page.
Page, my lords, 23.
2-3.
2-3.
Yes, come to grounds.
Means para 4 on what?
So Mahapatra, this order will go.
My lords.
This order will go on the ground of limitation only.
The ground of limitation.
Yes. You can't, nobody can initiate a proceeding after 6 decades.
That's correct, my lord, but fact means
If there is ability of fraud, then it could have been tested in a civil court, not in revenue courts.
Exactly, my lord. That I understood, my lord.
So therefore, the order must go.
May I submit, my lord? The fact remains there is an adjudication. Considering the substantial justice
Yes,
part,
in such belated proceeding, whatever finding comes, have to be ignored only. There is raising of such question. You have also filed. Now the serious question also. If an application for condonation of delay was there, if a party was noticed.
Yes, my lord, objection was filed. Objection also filed.
To this IA.
Yes, my lord.
Then has he passed an independent order on the condonation of delay?
Well, sir, that
Or
was,
it is taken together?
No, well, that was, I think that was passed in an independent order.
Delay has been dealt with in the impugned order itself.
Yes, impugned order as he was reading. He was reading just now. He has considered the claim and objection on limitation in the impugned order itself. So there is no independent consideration. Therefore,
kind of glass. My counter. I
what
quoted.
Counter, Mr. Mahapatra here? What counter here?
No, we have explained there, that particular.
No. I'll not go to counter. Sorry. These are statutory proceeding. No counter will be entertained here. Question. Now the great question, again supported by my judgment. If an application contains a delay condonation application, then decision on delay condonation must be taken up first before proceeding to finality. It cannot be a composite order because you are preventing a party from challenging that order.
Exactly, madam.
Mr. Mishra.
My
Mr.
lord.
Mishra.
My lord.
Let it go back to that stage. He will first take a decision on the limitation.
Keeping in view the position of law laid down by your lordship, my lord.
You saw that there. Listen, you are raising here 2 points. One is such a long delay should not have been condoned, as already observed by my decision already there. Second ground is limitation petition should have been considered before taking the final adjudication. So
the possession, one of the aspects where they have themselves admitted that they moved out of controversy way back.
What I find here is my judgment seems covered. Why to struggle so much? Let the matter go. Let the order go.
But my humble contention is that
you can't succeed even in the event remand.
Let's kindly visualize what thing matters. Right or wrong, the concept of possession is there. They say that they sold it and we say otherwise. But the thing is that sold it is under challenge and all these things. That is a different part altogether. My humble contention,
There is a civil suit pending.
No civil suit.
No civil
No
suit.
suit. That is, there is no civil suit pending, my lords. My humble contention is that, my lords, the revisional authority, considering all these aspects, passed that order. Now, there are two aspects. If it will be remanded, my lords, so far that my lord says that about
Remand, no purpose will be solved.
so far that limitation part is concerned. Limitation,
Yes,
my
sir,
lords, we have
that
explained it
limitation
in a
will be
way.
Succeeding surely.
We have explained in the way, my lords, that in two aspects. One is, my lords, that the particular, my lords, we came to know and from the date of the knowledge. One part. The second part is that the substantial justice, my lords, to be rendered, and this will not stand in the way. It is not a case that I know and I've ignored it. It's not a case that I know that and I ignored it.
Where is my judgment on, Mr. Mishra, where is my judgment on delay that big case? Mr. Sonok Mishra was arguing.
Lordship.
What is that case number?
Citation, Lordship. I don't have with me right now. I'll provide you, Lordship.
Please, provide in a slip.
Lordship.
You have got that judgment?
And Mr. Joshi is having it.
I have discussed what should be limitation in a revenue matter, taking into account the Supreme Court judgments and ignoring a division bench judgment of this court.
Well, that is the my lord's decision. My lord's decision, that's
Yes.
3 years, my lord, that my lord's have said.
Bhatta Sahu.
Bhatta Krishna, sir.
Krishna Sahu versus State of Orissa.
Bhatta Krishna, sir.
He will give it in. So, Mr. Mahapatra, no further argument. I am closing this. So, this decision will be taken away. Impugned order will be set aside. And as an outcome, what will happen to the second case?
The second case, well, obviously, the first case, if I will not succeed, the second case will go.
Gone.
The second, obviously, if that order is not there, then obviously there will be no question of mutation. May I only humbly submit one thing, my lords.
Sorry. 6 years after, 6 decades after.
Well, that is there, my lords, but fact remains in some cases, in some contingencies, this
Some
happens.
contingency, provided that contingency is expressive contingency. There is no allegation of fraud.
So, expressive contingency in the
Then lot of things are there, Mr. Mahapatra.
Yes.
Sorry. A second case to fail automatically. Yes, it will be today's judgment.
Yes.
ଡାକିଦେବେ ହେଲା ଏଇଟା ରହିବ important.
Obliged.
ଆଉ oblige କାହିଁକି ଆପଣ ତ decision ଟା ମୋର ଦେଲେନି.
Lordship, that is WPC 4602 of 2016.
Decided on
this was reported, you know.
On 25th July 2022.
we are rather helping you, Mr. Mishra. Hey, Krishna versus State of Orissa. It is reported already.
That is reported.
It's reported also. I'll give the citation.
But here, my lord, something different. Here, my lord, something different concept comes, but any, my lord.
But once the delay affects, everything goes. Everything goes except a serious fraud allegation, which is an issue and decided accordingly. Yes. Orders.
For orders item 37.
Please, your lordship, madam. I have filed one IA for recall of order dated 1/8/2023. Since my name has not been reflected in the cost list, my lord. I am the affected.
Order dated?
Order dated 1/8/2023.
So you want restoration of that IA?
My lord.
That day your name was not there.
Not there, my lord.
Have you filed the list of that date?
In that case, I have filed one writ petition previously.
No. Have you filed the list of that date which can establish your name was not there?
I am not a party. For that reason, my name has not.
ଆପଣ ତ party ନୁହନ୍ତି ଆପଣ ନାଁଟା ଉଠିବ କେମିତି ସେଦିନ?
ଆଜ୍ଞା. I am not a party in that writ petition. I have filed IA.
You are intervener.
My lord, I am not intervener.
How?
I know that the demarcation case which was filed by one Gunanidhi
No, in what capacity you bring that application?
When the notice of the Tahsildar, notice, my lord, annexure kindly, annexure.
That
I
is
came to know that one read
IA
petition is filed.
10968.
Annexure 4, page 20. Annexure 4. Notice was issued to me, my lord, for demarcation of the land.
So you are likely to be affected by.
My lord, my lord.
Therefore, you are an interested party.
I have filed
Then
IA.
you should have come by way of intervention.
My lord.
Is it intervention application or not?
No, my lord. I have filed one WPC. Your lordship directed me to file IA for clarification of the previous read petition order, my lord. That is WPC number 13.
So that will be taken care there.
My lord.
In this read, why have you brought a read petition?
My lord, since civil suit is pending, my lord, during pendency of the civil suit.
Who is for the petitioner? This matter is pending.
No, my lord,
Who
this
is
is
for the
this is
petitioner?
a dispose of case, my lord. 2021, it has been
It's a
disposed of.
dispose of case.
Yes, my lord.
The demarcation is already undertaken or it is still pending?
My lord, regarding that, I have to obtain instruction.
Pending.
Still pending. So I will only observe in the event you raise your objection, it will be entertained and considered. That's all. At the submission of respective councils.
Since civil suit is pending.
Oh, you bring that objection there.
My lord, my lord, my lord.
Consider all these things.
Now your lordship's order is there, na?
Right, you bring it there.
My lord.
For the submission of respective council data, IA 11988 of 33 by third party claiming to have interest in the demarcation proceeding involved herein being filed in a disposed of petition considering the claim in the interim application and as this court find this court observed provided the demarcation proceeding by demarcation case number so and so
42 by 17.
40
by 17.
40
42 by 17.
42 by 17 is still pending consideration. Petitioner's objection. You have already brought an objection?
My lord.
You have already brought an objection there?
Yes, my lord.
Okay, since petitioner has already, the interim application petitioner has already brought an objection to such proceeding, same shall also be taken into account giving the outcome ultimately. With this observation, the requisition stand, the highest stand disposed. Right, yes.
Hopefully.
Okay. Item 38.
Lord, now IAFL OP number 2 and 3 गोटे address ହେଇଯାଇଛି सेटा ମୁଁ ଗୋଟେ IA ବି file କରିଛି ତା ପାଇଁ.
Okay, this is an application for amendment in the cost title.
Yes, my lord.
In the correction of OP number 2 and 3. Okay, all right. Considering the relevancy involved herein, this court allows the application, permit the petitioner to bring fresh cost title by day after tomorrow.
Yes, my lord.
Okay, requisites being filed, notice be issued to opposite parties in terms of order dated 4/8/23, interim order to continue. Yes.
Item 39. Item 39.
Hey, please, your lordship.
Yes, 39, there is a inadvertent omission. Mr. Das, where is he? He was there. There is a inadvertent omission. We are correcting it. You will be granted liberty to move other court for expeditious hearing.
Yes, ma'am, that will be.
Right.
But it is 41 item.
अच्छी ता प्रकारे भूल कर दीजिए.
Well, I need pardon, ma'am, that is
Yes.
41 item. That one is 41. Well,
अब इटा कौन?
it out is
My lord, I am there.
39 रे क्या अचंती?
But I am there on VC, my lord. Your lordship will kindly.
Okay, all right. What is this then?
My lord, I filed an IA 12627 of 2023.
Yes.
For recall of your lordship's order.
Why?
If your lordship kindly sees.
It's a final order.
It's a final order, my lords. It is due to the fact that I could not bring certain information to your lordship, which is also the law laid down by this honorable court. The Lordship will see the order dated 10th of August.
All right, interim application allowed, order dated 10/8/23 stand record. Matter be placed for fresh admission again.
My lords, oblige, oblige.
Item 40.
Item 40, I have filed a application for modification of the order. In the order, it has been mentioned the demarcation case number 23 of 2022, but in fact, it is demarcation case number 23 of 2023. Only the
23.
year.
It is our mistake. All right. The year mentioned against the demarcation case in the first line, para 2, stands corrected as 2022.
Yes.
I stand dispatched accordingly.
Item 41.
This is mine, my lord. Yes, fine. That order part is there. Due to live stream, we could get it comfortably.
Okay, okay.
Okay.
Yes.
For addition. Item 42.
Mr. Mahanti, you are waiting in this matter, but I don't find it now convenient for giving any judgment.
They have served some documents yesterday.
Pardon?
Yesterday evening, they have served some documents. And that too, they have to give in a list of documents by way of affidavit or something. So that has not done. Some documents they have sent it by WhatsApp.
Okay.
So either they have to file, if they want to file it, file.
If you want to adopt any document,
Lordship.
What is this proceeding, Mr. Mahanti?
This is a out of MSME.
Out of
MSME proceeding.
Okay.
So mirror that IDP proceeding, they have initiated, though the contract says that Bhubaneswar court will have the jurisdiction, exclusive jurisdiction, they have started it in the Thane. So there mirror the objection was raised, that was not dealt with. Then the writ petition was filed challenging the proceeding. When the writ petition was filed, not taken up, during that they have passed the ex parte award. So that
It is not
award.
the fact.
Yes,
What
yes.
he is saying, it is
No,
not
no,
fact.
kindly see ex parte award.
Let him complete, Mr.
So ex parte award was, Miller, that was, we have filed an application for amendment that was taken up and amendment was allowed. And court has granted stay of the ex parte award. Now we are challenging the proceeding and also the award. Both we are challenging. And we have taken the point of jurisdiction at the first instance.
Mr. Dhole.
Yes, sir.
You are Mr. Dhole?
Yes, sir.
Okay. If it is an ex parte order, let the award go.
It is not ex parte order, Lordship.
The proceeding has to go.
No, there the objection will be raised and they can
No,
consider.
no, objection was raised, my lord. And my lord, they have not considered. They have not considered, they have passed this. So now, my lord, we have, since we have challenged, the proceeding has to go, my lord. My lord, the court has to take up both, my lord. Because this court has to.
So it will take some time.
It is not ex parte order. That is what I want to.
Okay, all right. Even going to the merit of the case,
No,
I don't have that much time.
No,
now.
that is different, sir. But what my friend is saying.
What is the need of arguing further?
No, all right. Because already I have given all the
I'm
details.
delisting, but question remains: if you adopt some document, then it should come by
No, I am not
amendment.
Yeah. No, it is not a question of amendment. Already I have disclosed in my reply, and it is their document. How they have acknowledged my date and all that, they should have submitted in their petition.
It is all document already available on record.
It is already because I have mentioned in my petition.
No, not on record. Not on record.
I have mentioned in my
Either, Milord, either he may file it, as it has to be filed in the procedure.
But there is no document brought to us, to the court at least.
No, they have sent us. Milord, that is what.
No, WhatsApp of the High Court is not.
No, it is already, but it was yesterday submitted anyway, Lordship.
Not in the file, they have to give us, Milord, in a proper
Then
form.
bring by way of affidavit at least. Let them get the opportunity of objection.
No, I have supplied, but I will give affidavit. Doesn't matter.
Okay,
If matter is so.
Because this matter needs final hearing for the involvement of complicated questions. This court find there is shortage of time with this court particularly. matter released from the board. It is at this stage of the matter, Sri Mahanti Senior Counsel brings to the notice of the court that there has been bringing in some documents simply by texting such documents through WhatsApp.
No, it is not, physical copy is also given to them. And I have.
No, they have not.
No, now he say, no, I can't say anything.
Just listen, what is the order? Listen, thereafter,
yes,
you may
yes.
submit. Okay, Mr. Mahanti objects entertainment of such documents. Sri Dhole has no objection in bringing in such documents by way of affidavit. Let such affidavit be brought in incorporation of documents, if any. Okay, how much time you want to bring such affidavit?
I can, next, after 6 of the September. Because up to 6.
How much time you tell? 3 weeks time, 2 weeks time, 1 week time. Stay is operating. They are in enjoyment of stay.
Yeah. Within 1 week, I should.
Within a week. Okay, within a week. With service of copy of the same on the counsels, on the attending counsels for the petitioner. In such event, it may be open to the petitioner also to bring an objection to such affidavit, at least within a further period of 7 days of receipt of such copy. Matter may be placed in the next board on along with any such document.
Interim orders, interim order.
Interim order to continue till next date. Really, wherever possible, I am hearing matters and dictating orders here.
I know.
No, but one thing is I have found that my friend, he should have given correct information to the court. That is what I am very much afraid of.
Which one? Hard copy now you are giving.
No, it is not like that.
Now
everything now. Yesterday.
Mr. Dhole, that should not. Mr. Dhole, that
was
not
not
any
WhatsApp.
controversy on that.
No, in WhatsApp.
No,
What are you saying?
it is what I am saying is.
No, it's not correct.
Anyway,
Do
but
you
it is-
correct.
it
Do you
is
get any weightage on that?
It's not correct.
Matter is adjourned.
Sir, you ask your associate. Why are you
All right,
asking?
sir.
And the
No,
matter
this
will
is
be
I-
heard by a
I take
by a
exception,
different
Bilal.
person. You will
I
not
take exception.
remember what
What
is
is
happening
Mr.
today.
I also take
Please,
what I-
please.
Please find out him. Bro, kindly please let him find out.
Forget.
No, this is
I am not entering into such controversy.
like that. What are you saying?
Pardon to Mr. Mahanti. Mr. Mahanti.
Kindly, they have sent it, what they have done, they have sent it in the
In
WhatsApp.
WhatsApp, I said I have recorded that.
So he received it.
Hard copy, there is no issue. There is no system of serving copy outright only. You may bring it by way of affidavit. That's the procedure. Yes, all right. That's over. Receipt, that is a receipt of service of copy on government. You don't get that receipt from the other side council. Mr. Dhole, you might have served on the government.
Yes, and my
So
associate.
therefore, don't enter into misunderstanding. It will not give you any weightage.
That doesn't matter.
Yes. ये ଦେଇଛନ୍ତି ସରକାରୀ କାଉଣ୍ଟରରେ ଦେଇଦେଇ ରସିଦଟା ରଖିଛନ୍ତି. The young counsel is the creator of mischiefs. Yes. ସେ ନେଇକି ସରକାରୀ କାଉଣ୍ଟରରେ ଦେଇଦେଇ ରସିଦଟା go entertain him by a cup of coffee. Yes. ये सेया ହେଇଛି ଜୁନିୟର କାଉନସିଲ ତାକୁ ରସିଦ ଦେଇ ଦେଇଛନ୍ତି ତେଣୁ ସିଏ ଡେଉଁଛନ୍ତି ଦିଆ ହେଇଛି କପି ଦିଆ ହେଇଛି ଦେଖୁଛି ଦେଖେଇଲାରୁ ମୁଁ ଜାଣିଲି. Yes, next ଦିଟା କେସ୍ କାଲି ଥିଲା କଭର ହବ କହୁଥିଲେ କୋଉ ଦିଟା କେସ୍ ସେ ଦିଟା
WPC 17254 of 2021.
ଟିକେ
43 Act.
କେତେ 17
17254 of 2021 madam.
କେତେ ସିରିଏଲ କେତେ
43.
42
43.
all right ଗୋଟେ 43 ଆଉ ଗୋଟେ
ନା ଆଉ ଗୋଟେ ସେଇ ଗୋଟାକ ହେଲା ବସନ୍ତ କୁମାର ସାହୁ WPC number 18891 of 2023 ରେ କଭର କରିବ.
ସେଟା କଭର କରିବ କେତେରେ
WPC 188
Hmm.
91 of 2023 Basant Kumar Sahu versus State.
এইটারে ମୁଁ ଆଉ ସେମିତିଆ ଅର୍ଡର ବି କିଛି କରିଥିବି ସିମିଲାର
ଏଇଟା ଗୋଟେ ସେ order ଟା ଖାଲି vigilance case ରେ ଯୋଉ order ଟା
ଓକେ
କରିଥିଲେ।
ଓକେ ଅଲ୍ ରାଇଟ୍ ଦିଅ ଫାଇଲ ଦେଲ ଫାଇଲ ଦିଅ ଏଇ ଯୋଉଟା ଧରିଛି ଅଲ୍ ରାଇଟ୍ ଲେଖ ରିପିଟିସନ ଇନଭଲ୍ଭ ଫଲୋଇଂ ପ୍ରେୟାର in the course of hearing and after taking into account the rival contentions of parties, this court find the issue involved herein is already stood covered by the judgment of this court in WPC 18891 of 23 decided on
20th July 2023.
20/7/23.
ଆଜ୍ଞା।
Okay, all right. Accordingly, this case stand disposed in terms of the direction in the aforesaid case. Let the petitioner. Okay, it will be worked out then
Yes.
within the outcome in terms of the judgment so and so involving the issue involved herein be brought at least within a period of 1.5 months from the date of communication of order. Let the petitioner serve copy of the order of this court in this case along with the certified copy of judgment in WPC 18891 of 23 to the competent authority at the secretary of the development authority at least within a period of 1 week of the date of order. Yes. Now, what is the other case? Yes, no, Patnaik Bastile.
Yes, ma'am.
Patnaik Bastile. Out of cover ଅଛି?
ନାଇଁ ଏଇଟା ମୋର ଯୋଉଟା ଅଛି 46 ଟା 46 ସେଟା ହଉଛି the only issue remained matters about that filing.
ଆଉ ଆଜି ତ ଟାଇମ ନେଇ ଦେଖିବା କାଲିକି ନହେଲେ ଦେଖିବା
Item 47, my lord. The appeal provision is there. Well, I am for.
ଟିକେ ରୁହନ୍ତୁ ଆଉ ଗୋଟେ କେସ୍ ଅଛି ଏଇଟା କଣ ଇନଫ୍ରକ୍ସସ୍ ହେଇଛି ବୋଲି ସୁକୁମାର ଘୋଷ କହୁଥିଲେ କାହାନ୍ତି
Item 44.
ହଁ 44 ନାଇଁ ମିଷ୍ଟର ପଟ୍ଟନାୟକ 44 all right.
That Telugu burial ground.
ହଁ କଣ ଇନଫ୍ରକ୍ସସ୍ ହେଇଗଲା ବୋଲି କହୁଥିଲେ
In view of this instruction, my lord, it is the duty of municipal council to appear, my lord. His name is there. But pursuant to your lordship's direction, we have taken instruction and this is our instruction.
ଦିଅନ୍ତୁ that Telugu burial ground
Yes, my lord. That situated.
ସେଟା ଇନଫ୍ରକ୍ସସ୍ ହେଇଯିବ ମାନେ କଣ ଆଉ ତେଲୁଗୁ ମରିବେନି
ନାଇଁ
ଆଉ ମରିବେନି
No, my lord. It was earlier allotted by the urban department.
ଟିକେ ରୁହନ୍ତୁ ଦେଖିଦବା ଶୁଣନ୍ତୁ
Right, yes.
earlier one place of land was selected for development of Telugu burial ground at Bhuasuni near Mahanadi River embankment.
Yes.
Earlier ହେଇଥିଲା. It was not accepted by the community, hence another ground near Satichora has been allotted for the purpose. Functioning after development of the following construction work. Functioning already କହୁଛନ୍ତି
No, my lord. In fact,
ତାହେଲେ ଆମେ କହିଦବା ତାକୁ make ready.
ନାଇଁ ସେଟା ଫଙ୍କସନ କରିବ ସେ କାମ ଗୁଡା ସରିଲା ପରେ
ଏଇ କାମ ଗୁଡାକ ହବ
ଖାଲି ଆଉ ସବୁ ସରିଲାଣି ଖାଲି ବାଉଣ୍ଡରୀ
ଦେଇ ଦଉଛି କଟକ ମ୍ୟୁନିସିପାଲ କର୍ପୋରେସନ କୁ ତାକୁ କମ୍ପ୍ଲିଟ କରିବେ
ହଁ ଖାଲି ବାଉଣ୍ଡରୀ ୱାଲ୍ ଟା ବର୍ତ୍ତମାନ ଟେଣ୍ଡର ଡକା ହେଇଛି
ଡକା ହେଇଛି
earlier, my lord, earlier it was constructed Mata and provided 30 lakhs. Yes, 30 lakhs.
Serial number 1, 2, 3
Boundary wall, water supply, as well as to.
এটা area of the ground allotted, so যেতে ହେଲା serial number description ଓ ଏଇଟା ହେଇଛି tender ଏଇଟା. Okay, tender invited ଲେଖା ହେଇଛି.
ସେଟା ସରିଗଲା ପରେ complete
close କରିଦବା.
Yes.
Close କରିଦଉଛି time stipulation କରିଦଉଛି.
They have neither they have communicated the information to the community.
I'm taking down it.
Yes.
You will get it in the order itself.
My lord, item 45 for the
You are for
municipality.
municipality. ये कटक म्युनिसिपल कॉर्पोरेशन ही इंस्ट्रक्शन ଦେଇଛି ସେଟା ମୁଁ ଲେଖୁଛି ଟେଣ୍ଡର କେତେ ଦୂର ଗଲା
2 instruction. Hello, 2 weeks time.
ଆଉ 2 weeks time କିଛି ନାହିଁ ଶୁଣନ୍ତୁ ମୁଁ ଆପଣଙ୍କୁ ସମୟ ଦଉଛି ବରିୟଲ ଗ୍ରାଉଣ୍ଡ ଟେମ୍ପୋରାରୀ ୟୁଜ ହବ ବର୍ତ୍ତମାନ ହେଲା ୟୁଜ ହଉ ଆପଣ ଏଇ ରେଷ୍ଟ ରୁମ୍ ଟଏଲେଟ ବାଥ୍ ଇନକ୍ଲୁଡିଂ ସ୍ୟାଣ୍ଡ ଫିଲିଂ କରିବେ କିଛି
ନାଇଁ ନାଇଁ ସେଟା ଅଲରେଡି କମ୍ପ୍ଲିଟେଡ୍ ସେ ଲେଖା ହେଇଛି କମ୍ପ୍ଲିଟେଡ୍
ଓ
ବୋଲି
ସେଟା କମ୍ପ୍ଲିଟେଡ୍
ଖାଲି boundary wall.
ଟେଣ୍ଡର ଇନଭାଇଟେଡ୍
Gender invalid.
ବାଉଣ୍ଡ୍ରି ୱାଲ୍ ମୁଁ କହିଦଉଛି ଆପଣ ଟେମ୍ପୋରାରୀ ୱାଲିଂ କରିଦିଅନ୍ତୁ ଟିଣ ବାଡେଇକିରି ହେଲା ଟେଣ୍ଡର ହେଲା ପରେ ଆପଣ କମ୍ପ୍ଲିଟ କରିବେ ଟିଣ ଉଠେଇ ନେଇ ଚାଲିଯିବେ let the burial ground come into picture at least before my departure
My lord.
Yes, yes.
Thank
They
you.
should have communicated to the applicant
Thank you,
also.
thank you. ହେଲା ଶୁଣନ୍ତୁ ନ ହେଇକିରି ବି ଭିତରେ ତ ଡେଭଲପମେଣ୍ଟ ହେଇଯାଇଛି ଆପଣ ବ୍ୟସ୍ତ ମୁଁ ଜାଣିଛି ଛତିଚୋରା ପାଖରେ ଗୋଟେ ହେଲା ବୋଲି ପେପରରେ ବଡ ଜୋରରେ ବାହାରିଥିଲା କିନ୍ତୁ ଇଏ କହୁଛୁ ମାନୁନାହାନ୍ତି Okay, had the submission of the councils involved in repetition involved the following prayer. This matter was being had on several occasions. There has been also in the course of hearing, communication of the Cuttack Municipal Corporation dated 16/8/23 to the State Council has been brought to the notice of the court. There is also no dispute to the said communication by the council appearing. Your name, please?
SK SAHOO. SK SAHOO.
SK SAHOO. SK SAHOO.
His name is there, my lord, with Devashish Naik.
Shri SK SAHOO along with Shri Devashish Naik appearing for Cuttack Municipal Corporation in the contents in the said letter. For better appreciation, this court takes down the contents therein as herein follow. ହେଲା ଏଟା କୋର୍ଟ ହବ ଏଠି ମଲ୍ଟିପୁଲ ଲେଟର୍ସ ଅଛି ସେଇ ଜିନିଷଟା ଅଛି କପି
ତିନିଟା କପି ଅଛି
ଗୋଟେ କପି ଆମକୁ ଦେଇ ଯାଉଛୁ
ଆଜ୍ଞା
ହେଲା Okay, this one. Okay, the court ହେଲା ପରେ ଲେଖିବ ଗୋଟେ SD ବୋଲି ଲେଖିବ ତଳେ ତାଙ୍କ ଡିଜିଗ୍ନେସନ ଦବ SD ବୋଲି କରିବ ଡେଟ୍ ଦବ ଲେଖ reading the aforesaid this court find not only there has been shifting of the Telugu burial ground from Bhuasuni near Mahanadi river embankment to Satichora area, but there has been also finishing of work in the allotted area of acre 1.13 decimal by completing the construction of restroom with toilet, bath including sand filling with estimated cost of rupees 49,98,800 stood completed as of now. The only work pending appearing therein appears to be construction of the boundary wall, estimated cost 21,97,000. This letter also clearly disclosed there is already invitation of tender. Finding the boundary wall construction is already put to tender process. Considering the construction of the boundary wall may take some time while permitting the municipal corporation to complete the construction of boundary wall at least within a period of 3 months, the Telugu burial ground may be surrounded by temporary boundary wall for immediate operation of the Telugu burial ground. The temporary walling may be completed at least within 10 days hence. This free copy of order be handed over to. With this direction, the requisition stand is for. The free copy of order be handed over to State Council as well as the Municipal Council. Yes.
My lord, just see the annexure 1. It should be notified by the mutated by the Tahsildar.
Considering the submission of Sri Patnaik Learned Council appearing within this court, direct the municipal corporation to bring a notification informing the Telugu community on the above development already taking place. At least on the establishment of the Telugu burial ground. अरे सी तो तांगर गोटे काकू डाकिगिरी सेठी करबा कथा इनागुरेशन करबा कथा
आज्ञा
आता कटक रे इनागुरेशन करबेनी फलक लगेबेनी
हां
तेलुगु ग्राउंड रो
आगुर मध्ये जाइथिले अर्बन मिनिस्टर एवं एमपी सब जाई की करथिले एटा इनागुरेट
For the general communication to the community itself. So it is over now. Very good, file. How quota?
My lord, one small prayer, my lord. Your lordship kindly recollect that item 48. Yesterday it was item 6. Your lordship direct, they took time, my lord. Mr. Sanam Mishra is there, my lord.
Kali shuniba.
Kali as fresh admission, because yesterday it was on fresh admission.
Okay, it 48 fresh admission rano. And 8 भी fresh admission rano. Mr. Mahapatra, आपको quota.
Item 46 टा जोटा जो BDR गोटे CDR जो matter गोटे रही है task force ऊपर जोटा जो 46 टा
46 all right.
Item 47.
46 भी fresh रे नहीं है sir.
Item 47, my lord.
47 कौन matter?
There is a petition, writ petitioner challenging the order of a CWC, but there is appeal provision is there, my lord. Instead of filing the appeal, file the writ application.
Yeah, आपको petitioner.
I'm appeal number 3.
Petitioner कहाँ थी?
I am appealing for the petition.
So go prefer appeal.
What I said, Lord CWC has no jurisdiction to entertain, because he has given custody from the
challenge the on the ground of entertainability.
Yes, my lord.
Okay, all right, let it be there.
Where is
Lord, item 45.
101 section.
Yeah, let it be there.
My lord, item 45, I'm appearing from BC, my lord, for it was item 45, your lordship. My lord, it will take a lot of time, my lord. This is, my lord, there's an interim order already continuing. Lordship, I kindly extend the interim order.
Jota ita 45 delist dela, 47 delist dela, interim order wherever to continue, hala?
Yes, your lordship. I'm grateful.
45, my lord, delisted.
Lordship 47 delisted.
45 delisted, my lord.
हाँ release कर दो कि मैं करी परिविन सब matter.
Obliged.